Yes, you are audible.
A very warm good afternoon to respected Head and Dean of Faculty of Law, University of Lucknow, Professor C.P. Singh, sir. Venerated speakers, Mr. Harjot Singh, Ms. Iram Majid, Mr. Manish Mehrotra, and Mr. Panchashidev Sharma. Respected Chairperson of Lucknow University Moot Court Association, Dr. Vinita Kachar ma'am, and all the thrilled students and participants. I, Ibtida Fatma, on behalf of Lucknow University Moot Court Association, feel privileged to extend my warm welcome and thank you to all for joining us on the second day of the International Workshop on Emergence of International Arbitration Tribunals as New Justice System in India, Future Opportunities and Challenges. International arbitration has emerged as the preferred method of resolving cross-border disputes. The neutrality it offers, together with the relative ease of enforceability of awards, can make it a more attractive forum for disputes than litigation in contracting parties' national courts. Its sophistication continues to develop and its popularity grows. But how does it work? Who decides the dispute and according to what laws and processes? The central idea of the International Workshop is to guide us through these questions. The International Workshop was kick-started yesterday, that is on 28th November, wherein it witnessed an incredibly valuable contribution by three very esteemed and celebrated dignitaries in the field of law, Honorable Justice Dr. Kaushal Jayendra Thakur, Professor Dr. Ramesh Gautam, and Advocate Mr. Margab Kabir, who discussed the varied facets of international arbitration. Before we proceed on with the day two of the event, I would request the chairperson of LUMA, Dr. Vinita Kachar ma'am, to please address the participants and one and all present here with her words of encouragement. Over to
Very
ma'am.
good afternoon. A very good afternoon to all of you who have joined us. I'm Dr. Vinita Kachar. I take this privilege to warmly welcome our speakers and participants on the second day of the International Workshop. Yesterday we had very engaging, innovative and educative lectures, as has been told by Ibtida. Today our first speaker is Mr. Harjot Singh. Mr. Harjot Singh specializes in international litigation and commercial arbitration. He has 19 years of professional experience of corporate and litigation before the Supreme Court and High Courts in India, and nearly 14 years experience in the courts in the United Kingdom, and has worked with reputed law firms. Presently, he is working as director with Twinwood Law Practice Limited dynamic law firm based in the UK. He has a lot of landmark Indian and UK cases to his credit. And I would definitely like to mention here that he's an alumni of Law Faculty, Lucknow University. Welcome, Mr. Harjot Singh. Our second speaker today is Ms. Iram Majid. Ms. Iram Majid is an IMI certified and IIAM accredited mediator and member Chartered Institute of Arbitrators, London, UK, based in New Delhi. She is director of Indian Institute of Arbitration and Mediation. She is executive director of Asia Pacific Center for Arbitration and Mediation. She has undergone training for arbitration from Chartered Institute of Arbitration, UK, and Indian Institute of Arbitration and Mediation, including the Harvard Law School for Advanced Mediation Program on Negotiation. She's co-founder and Secretary General, International Federation of Mediators in France. She's APCOM certified arbitrator and in panel as arbitrator with all member countries like Hong Kong, Australia, Indonesia, Nepal, Malaysia. She has also participated in various seminars as delegate and speaker in Hong Kong, South Korea, Indonesia, Bangladesh, France, United States of America, Tanzania, etc. Ms. Iram is member of Thailand Arbitration Center, International Federation of Mediators, Indian Institute of Arbitration and Mediation, an ambassador and in International Brazil Arbitration and Mediation Center. On behalf of Law Faculty, Lucknow University, ma'am, I warmly welcome you. And your topic is very relevant for our students and especially for all the participants also. And we are looking forward to your talk, ma'am. Our next speaker is Mr. Manish Mehrotra. Mr. Manish Mehrotra is a senior practicing lawyer in Lucknow. And he has a specialization in arbitration law for last 28 years. Mr. Malhotra has appeared as senior lead counsel in more than 130 arbitration cases on behalf of several corporate clients in all over India. Mr. Manish Malhotra has been the keynote speaker on the subject of ADR and quick justice in various training sessions and courses designed for civil and district additional judges of Uttar Pradesh. He has been a regular speaker on arbitration law since last 2 decades. I warmly welcome you, sir, on behalf of Law Faculty, Lucknow University. And our fourth speaker is Mr. Panchashidev Sharma. He's a member of our faculty. He's an assistant professor in Lucknow University. He's a gold medalist in LLB honors and LLM, and is now pursuing his PhD from University of Victoria, Canada, and one of my very brilliant students, Mr. Panchashidev Sharma. So today we'll be starting with Mr. Harjot Singh. Welcome, Mr. Harjot Singh.
Thank you very much, ma'am. First of all, I would like to thank Dr. C.P. Singh ji, who's my mentor, my professor, and I've learned. And thank you very much, in fact, for the invitation. Coming back to Lucknow University is very, very emotional, and coming back to Lucknow is very emotional. I've been here practicing here for 15 years now, and always, Lucknow University is the heart and soul. So thank you very much, Dr. Vanita Kachar, ma'am, for the introduction, very warm introduction. Dr. C.P. Singh ji, who's a mentor who guided me through the Moot courts and, really inspired me to do something. I also welcome Ms. Emergence. I've just heard, very, very successful in arbitration. My senior and my elder brother, Manish Malhotra ji, he's a senior advocate. I've seen him in action in many, many cases. Brilliant lawyer, senior advocate. Mr. Panchashidev Sharma ji, again, my friend and brilliant person in academics, and my dear friends and students. Coming back to Lucknow University, as I've just said, it's very emotional. So connecting back to you is like coming back home, and speaking to my brothers and sisters and my friends and colleagues. Today, I really want to thank Professor C.P. Singh Saab, Vinita ma'am, for choosing this very important topic. And when Professor C.P. Singh Saab asked me that I should speak on arbitration, I was really thrilled, because I personally think arbitration is the future. It's so much coming now, that if you specialize in arbitration, you obviously Ms. Ara Majid is going to deal with it, but just at the onset, if you can specialize in arbitration, you can really have a global footprint. I've been doing arbitration for many, many years now. So, but today my topic is the current scenario, and I've divided my speech, my discussion, into 3 points. So the first point would be overview of the important provisions. The second would be latest changes, which are significant in my view. And the third is I would briefly discuss on the international and the Indian perspective, the case of Reliance and Amazon. Very much in talk, very much in media, and we can discuss some of the points which are being argued by Mr. Gopal Subramaniam. Again, he's like a mentor to me. He's arguing in the Reliance case, and the implication on one point, there's a case which is pending in the Singaporean Arbitration Center. One point, it's now in the Delhi High Court. So the implication is so interesting. And the scope of the emergency arbitration and emergency injunction orders, So let's start from the overview of the important provisions. I'll be very brief on this, because I know you would be reading about arbitration, but interim relief provisions, for example, very important. Under Section 9 of the Arbitration and Conciliation Act 1996, during arbitration proceedings, a party may approach the tribunal for any interim relief. Now, why I'm discussing this? Because when we are going to discuss about the Reliance case, the Amazon wanted some sort of interim relief, and this is what the argument is from the other side also. But here, under the Arbitration and Conciliation Act, Section 9 is very important. However, before an arbitral tribunal is formed or after it gives its award, the only forum which is available for interim relief are the courts here. Very important to note. So even though the courts are now dealing with urgent matters, remember this is COVID time, still the courts are closed, sometimes open, COVID reliance, only urgent matters being taken. So even when the courts are now dealing with urgent matters, the interim relief sought in Section 9 petition is in any case only meant for pressing claims that would warrant the court exercising its jurisdiction before even the tribunal is formed. So this is very critical, because when you go into practice, and just yesterday on Friday, the Law Society president said in you, and one of the very senior judges said that, what we have learned as lawyers in the COVID era, everything is in digital mode. We're arguing. Look, I'm speaking to you sitting in London. It's so different. It's so great, and we can all connect. So this should not be lost in the post-COVID era. Vaccines are there. It would be implemented very soon. So, we'll be back to normal. But this is great. So in terms of that, Section 9 of the Arbitration Act is very important. When you go into practice, you should really look into the case law. Where, in what scenario can you get interim relief provisions in arbitration? So the second important, I would always tell the students, is appointment of arbitration. So arbitration clauses usually contain a party agreed procedure to appoint the arbitral tribunal, which are often unsuccessful due to parties' inability to reach, an agreement, because there's animosity already, by the time you say, I want to do arbitration, the letters exchange and everything. So but what happened in situations in an ad hoc arbitration, the parties have to approach the court under Section 11. So Section 11 is very important of the Arbitration Act for appointment of an arbitrator. In the current scenario, again, I'm mentioning COVID because this is we are still like Serum Adhar Poonawala yesterday said, we are going to get vaccine by 2021. So, hopefully India being a very big country, we expect, these measures to be in place for next year. So Section 11 is very important. So in this such a situation, in an ad hoc arbitration, parties have to approach the court under Section 11 of the Arbitration Act for appointment of an arbitrator. In the current scenario, this will pose an issue because if the courts are not sitting and there's a video hearings, so it will cause an issue. I know personally, because in Delhi High Court I've been involved, it has been causing some issues, and it is unlikely that the court will consider an application for appointment of an arbitrator as extremely urgent. Now, so these are the two provisions, which a lot of new judgments and a lot of the new arguments are happening in Bombay High Court and the Delhi High Court. So but anyways, moving from there, Section 29A, a very I would say it's a very good timeline for arbitration, and it provides that the arbitral awards have to be given within 1 year of completion of proceedings. Now, again, because of the COVID, on the 23rd of March 2020, this year, the Honorable Supreme Court passed an order extending limitation period, stating that this court has taken suo motu cognizance of the situation arising out of the challenges faced by the country. So again, there would be a lot of arguments for and against on this point, but in normal times, I would say Section 29A is very important because that limits the time, and time is, speed is the essence in arbitration, my experience would say more and more parties are choosing arbitration because of the speed, because if justice is denied, justice would be denied if there's a delay. So, I firmly believe into that. So Section 29A, which was inserted by the Arbitration and Conciliation Amendment Act in the year 2015, fixes the time period for passing the arbitral award at 12 months from the date of reference to the arbitral tribunal when the notice of appointment is received by the arbitrator, and can be extended by another 6 months with the consent of the parties, and any further extension can only be granted by the concerned court. So it's a very important provision in the Arbitration Act, which helps in the speedy disposal of the claim. So any further extension can be granted by the concerned court either prior to or after expiry of the time period, failing which the mandate of the arbitral tribunal shall terminate. So brilliant provision again. Now, video conferencing, what we are doing right now, video links, Zoom. Section 19 of the Arbitration and Conciliation Act 1996 states that the arbitral tribunal shall not be bound by the Code of Civil Procedure and the Indian Evidence Act. The parties to the arbitration proceeding or the arbitral tribunal may decide on the procedure to be followed in the conduct of such arbitration proceedings. Now, when the Arbitration and Conciliation Act 1996, although, just be clear, it's silent on the conduct of arbitration proceedings through video conferencing. But again, I would submit in the present scenario, Section 19 certainly empowers the arbitral tribunal to allow the same. The arbitral tribunal can direct the parties to the arbitration proceedings to file pleadings through electronic mail and conduct proceedings through the means of video conferencing, aiding social distancing with a minimum loss of productivity. So these are very important provisions. And this is what I'm seeing from my professional point of view. A lot of litigation is happening right now in Delhi, Bombay, where people are going for emergency interim reliefs. They are arguing about the video conferencing systems, that that the things can progress, and Section 29A, of course, is so important. So now I'm going to deal with the latest changes, two latest changes, which are very important in my view. And I would say it's a changing landscape in India with respect to arbitration. So another ordinance has been promulgated to amend the Arbitration and Conciliation Act 1996. And there are two important inclusions. A, the unconditional stay on the enforcement of Indian seated arbitration award until the challenge of the award is determined, provided, this is very important, because this brings in line with the international law, LCIA and the Singaporean. So, all these are very important. So I'm going to say it again, provided there's a prima facie case finding by the court that the arbitration agreement or contract, which is the basis of award or making of an award, was induced or affected by fraud or corruption. Brilliant. So, now this is a very important inclusion. And the second one is, again, it's a great one because it is the deletion of much debated qualification, experience, and norms for accreditation of arbitrators stipulated under the 8th schedule of the Arbitration Act. Because what was happening, a lot of the foreign companies, multinational companies, they were shying away from having a seat in India because there was a clause in the 8th schedule that you only need an arbitrator who knows the Constitution of India, must be a citizen of India, and that's how it limits. Because one of my friends, he's a very senior lawyer in Singapore, and he's a QC, he's a Queen's Counsel, and he's head of the Dubai Arbitration Center. So he's very prominent in Dubai, although he's practicing in Singapore and London. So the point is, arbitration is a global system, and world is a global village. So I'm very grateful to the Indian government. It's a very important inclusion because that will now get international arbitrators to come to India, sit as arbitrators, and then the foreign companies and everybody will have litigation, arbitration claims in India. So it would really enhance us as the international seat, acceptable international seat for arbitration. India is great in terms of arbitration, but this was much needed. So on the first one about the stay, let's discuss briefly about that. So while the amendments are well intended, prescribing the scope of stay on the operation of an Indian seated arbitral award, it may lead to unintended consequences and open the door to a floodgate of litigation. Ultimately, it would result in the delay of the enforcement of the arbitral award, but it was very much needed, as I've said. So what happens now? The argument about the fraud or the corruption. So the issue could have been addressed by the parties. So what happens is, the arbitration agreement or the contract, which is the basis of the award, being induced by or affected by fraud or corruption. So this would be now in future, a lot of the pleadings will be reflected on this point, because this is a point which can really stay the proceedings, stay the relief, basically. So the issue could have been addressed by the parties in the specific stay application filed under Section 36 of the Arbitration Act in the enforcement proceedings. And the court has the wide power to pass appropriate directions as deemed fit in the case. With the new set of amendments, my dear students, a respondent to the arbitral proceeding. So if you are the respondent and you're just responding, will be tempted to plead that the underlying contract was induced by fraud and corruption. And then it has to be pleaded. So always remember, pleading is, you put that in the drafting. So they will be tempted to plead that the underlying contract was induced by fraud and corruption, knowing fully that this can be used as a ground to seek a stay on the operation of the arbitral award. A party always has a right to challenge the jurisdiction of the arbitral award under Section 16 of the Arbitration Act. And as such, the jurisdictional challenges are to be made before filing of the statement of defense. But with this amendment, if you can argue that the making of the award was induced by fraud or corruption, it's a second leg of the amendment to the proviso of Section 36 of the Arbitration Act, which allows now unconditional stay on the operation of the award. So if a prima facie case is made out, and remember, the respondent will be tempted to plead, and if you are able to make a prima facie case that the making of the award was induced by fraud or corruption, it is A, at par with international standards, so acceptable. B, it will eventually, in my respect, delay the implementation, but it was much required in the present scenario. The Honorable Supreme Court, there's a decision of the Honorable Supreme Court in Venture Global, has explained fraud in the context of making of an award and held that the suppression of facts, now this is very important, Venture Global is a very good judgment. The Honorable Supreme Court has explained fraud in context of making an award and held that suppression of facts before the arbitral tribunal may be construed as a fact, may be construed as a factual, as a fraud while making the award, but the facts concealed must have a causative link, and if the concealed facts disclosed after the passing of the award have a causative link with the facts constituting or inducing the award, such facts are relevant in setting aside proceedings, and the award may be set aside or affected or induced by fraud. So this is critical. So please, dear students, do study the Venture Global judgment. Very important. The Delhi High Court also recently in Sandeep Kumar versus Dr. Ashok Hans held that there is no requirement in the provision of Section 34 for parties to lead evidence, or it would be completely defeat the purpose. The record of arbitrator was held to be sufficient in order to furnish proof of whether the ground under Section 34 has been made out. This judgment is also very important, the judgment of Sandeep Kumar. There's another judgment, the Honorable Supreme Court judgment in Fizza Developers and Intertrade Private Limited, held that the application under Section 34 in the nature of summary proceedings, an opportunity to the aggrieved party has to be afforded to prove existence of any ground under Section 34, subclause 2 of the Act. So this is very important, these three judgments, Venture Global, Sandeep Kumar, and Fizza Developers. Please make a note and read about it, because this is going to be a lot more into court, this issue, and there would be a lot of pleadings in future arbitration proceedings in our country. Also, about the 8th schedule has been criticized widely due to the imposition of unfair restrictions on the ability to nominate a non-Indian arbitrate in India-seated arbitrations. I'm aware that, and I'm sure Ms. Iram Majid would be aware, and Manish Bhai, Sherry Blair, who's a QC here, she's the wife of ex-Prime Minister Tony Blair. She's a top lawyer, and she has done arbitrations in India. So look, that's how the Indian arbitration scene is growing. The top lawyers, and there was a case where Dr. A.M. Singhvi and Sherry Blair were opposing each other in one of the arbitration claims. But what happens now after the 8th schedule is removed, because it was widely criticized on the international scale due to the imposition of unfair restrictions on the ability to nominate a non-Indian arbitrator in India-seated arbitrations, because it discouraged foreign parties to see the arbitration in India due to inability to appoint foreign legal professionals and restricting their choice of potential arbitrators by nationality, likelihood of lack of experience in handling international arbitration. So because it's removed, it will really increase because don't forget, India is a land of opportunity. Even in the COVID time, we're getting a lot of foreign investments. And as a lawyer, you need to think positive. So when you're thinking positive and you're going into arbitration, this removal of 8th schedule will really will really pump up the demand of arbitration litigation in Delhi, in Bombay, and possibly in Lucknow also, So it would be really, it's really a good milestone by this government. Now let's discuss about this latest, the big case, Reliance, and look at the beauty, Reliance enters. So Reliance Retail Ventures Limited, which is RRVL, if you can say, uh, enters into an agreement with Future. Now Amazon has got a shareholding agreement. It's very complicated, but if I may just briefly narrate the facts. So what happens in August this year, RRVL announced that it had entered into a deal for the acquisition of the assets and business of Future Retail Limited, which is the Future Group we all know, for approximate 3.38 billion. Imagine the amount of money involved. Amazon, which is again a global giant, alleges that the transaction was violative of a shareholders agreement entered with the promoter of Future Group, because they had a separate agreement with the promoters, which is, we all know who's the promoter of Future Group. It is reported that Amazon proceeded to initiate arbitration proceedings before the Singapore International Arbitration Center against this transaction. And so Amazon was the first one to step in. They just rushed, because in that agreement, there was a clause, any dispute would be referred to the Singapore International Arbitration Center. Now, we need to understand, because we all know as law students that there was a emergency, injunction. So what is this emergency arbitration? Because emergency arbitrator, because we don't have that concept per se right now. We do have, I've discussed, that's why I've discussed interim relief. We do have that very important limb. But an emergency arbitrator is an actor unique to institutional arbitration. He or she is appointed pending the constitution of the actual arbitral tribunal to consider applications for urgent relief that cannot wait until the constitution of the actual tribunal. Now, what happens then? So on the one hand, from the Indian perspective, it is unclear whether an emergency arbitrator is an arbitral tribunal, because don't forget, in our law, there's arbitral tribunal for the purpose of Arbitration Act. And this question is very critical and crucial, because an action/order of a person not aggrieved by an arbitral tribunal would have no legislative value in our country. So the definition of Section 2, subclause 1, subclause D of the Arbitration Act is very, very important in this, and would be subject to interpretation in coming days. But we do not have yet an authoritative precedent interpreting this issue in the context of an Indian enactment. So on the one hand, there are cases, my dear students, where the courts have afforded due respect and regard to the emergency arbitrator process, and have even gone so far as to limit the scope of their own interim reliefs, so as to give room to the emergency arbitrators to provide such relief and as are appropriate. So, very important judgment, Steer Engineering Private Limited versus GlaxoSmithKline. Now, again, this is Delhi High Court. Ashwani Minda versus Yushin Limited, again, Delhi High Court. So these are two very important judgments. The Honorable High Court has gone extra length to adopt the concept, to interpret the concept of emergency arbitrator, and and about the process, and so it's very important judgment. But on the other hand, there are decisions where the court have clearly set out that an emergency arbitrator orders are not enforceable under the Indian law. For example, Rafael Designs International India Private Limited versus Udocomp. So the two different set of judgments. But in this case, the suit was filed soon after the Future Group entered into this agreement with Reliance. And it was there was an injunction received by an emergency arbitrator from going ahead in its deal with the Reliance. So that's why it's very complicated, because this is happening here, and the Singaporean court, Singaporean Arbitration Tribunal grants injunction. So because Amazon was an investor in one of the shareholders of the Future Retail, it initiated the emergency arbitration under the Singapore International Arbitration Center. Now, again, a SAIC is very important, and Singapore is really pushing itself to be a global place for for arbitration. And I personally know because Mr. Gopal Subramaniam, Mr. Hari Salve, they are appearing because they're both English barristers, English lawyers, and they're Indian lawyers, and they're members, of SAIC, and they are doing a lot of arbitration work in Singapore. So its primary grievance of the Amazon was that Reliance fell in a negative list of 30 entities with which Future Group could not transact. So that was the whole basis. And as an interim relief, Future Retail sought directions from the court to restrain Amazon from interfering in its performance of the lawful contract with Reliance. Because what happens now, once the injunction was there, they filed a case in the Honorable High Court of Delhi. Now, in the Delhi High Court, there have been battery of senior lawyers, and this case is going to be a very interesting case for all of you. Please, students, follow this case because Mr. Gopal Subramaniam is there. He's arguing for, he and Mr. Amit Sibbal, they're arguing for Amazon, and Mr. Singhvi, Mr. Hari Salve. So the top battery of lawyers are there. But let me just discuss with you the points which are very critical, which have been argued by Mr. Subramaniam, and that's important because what he has said, and I quote, because he said the ship of arbitration has sailed in the present case, and the suit was now not maintainable. He said that at the Delhi High Court. That look, the SAIC has already done it. They have put an injunction, emergency injunction. The suit is not maintainable. That's his first argument. And this is important because on these arguments, for and against, in future, there would be a big judgment. It would be a landmark judgment, and it will really, really solve the international and the Indian arbitration and their correlation. Because don't forget, we are so correlated. We are such a global village now. And I'm just going to finish my discussion with you after just laying out what Mr. Subramaniam has argued. Second, he argued was the parties are bound by the direction of the emergency tribunal. So you have to think as a lawyer whether they would be bound. The parties are in India and the SAIC is based in Singapore. Third, all contentions raised before the court were heard and decided by the emergency arbitrator in detail after considering the Indian law. Again, we argue, you're students of IPC, CRPC, jurisdiction is very important. Where's the jurisdiction going in this, dear students? It's a matter for future interpretation by the Delhi High Court and possibly by the Indian Supreme Court. Next point, the future group and the share subscription agreement were at the heels of each other, and there was a single integrated transaction. So he's trying to interlink all the transactions. That why the agreement, why there's a breach in the agreements. Again, contract law comes into place. And then finally, as an investor, Amazon has certain protective rights, but did not have control over FCPL or FRL. And very important, again, I discussed about the promoters because the promoters entered into agreement with Amazon. So he argued the promoters, Bianis, were common to FCPL and FRL and exercise control and rights over them. There was an agreement that FRL retail assets will not be sold without FCPL's consent. So, dear students, this is a brilliant case, which is in the Delhi High Court right now. Please follow this case, and it will eventually go to Supreme Court. And as I've just mentioned briefly, because of the paucity of time, the importance of Section 9, Section 11, Section 19, and then coming the two good changes proposed, by this government, by means of ordinance, especially the removal of 8th schedule. There would be a lot of arbitration in coming days because a lot of the foreign companies would like to have the arbitration here because they would have a choice now to appoint international arbitrators in the composition of the tribunal. And please follow the Reliance and the Future and the Amazon case because that will be a benchmark how the foreign tribunals, the SAIC in this case, and the Indian courts are interrelated. And wish you all the luck. And thank you very much for giving time. Again, thanks to Dr. C.P. Singh Saab and to all the students for listening me patiently. Thank you very much.
Thank you so much, sir. Thank you for boosting up the spirit of our audience by sharing your proficient anecdotes with us. We express our utmost gratitude towards you. Before we proceed on with the event, may I please request Professor C.P. Singh, sir, to share a few welcoming words for our speakers and grace the event with his presence.
Thank you, Mr. Harjot Singh.
Thank you, sir.
For delivering very good and inspiring lecture. Miss Majid, Director, Indian Institute of Arbitration and Mediation. Mr. Manish Mehrotra, Senior Advocate, Allahabad High Court. Mr. Panchashidev Sharma, our own student and colleague and research scholar. आज प्रोफेसर विनीता काचर के नेतृत्व में लखनऊ विश्वविद्यालय के मूट कोर्ट एसोसिएशन द्वारा आयोजित इंटरनेशनल आर्बिट्रेशन पर जो वर्कशॉप हो रहा है, आप सभी महानुभावों का, विद्वानों का, जूरिस्ट का, प्रोफेसर एस.के. चौधरी एडवोकेट जी का, सभी का जो है इस वर्कशॉप में स्वागत है, वेलकम है, अभिनंदन है। फैकल्टी की तरफ से मैं आप सबका स्वागत करता हूं, वंदन करता हूं, अभिनंदन करता हूं। आप सबने जो समय दिया है फैकल्टी के लिए, फैकल्टी इसके लिए सदैव ऋणी रहेगी, आभारी रहेगी। हम आशा करते हैं कि आप भविष्य में भी हमें जब भी आवश्यकता पड़ेगी, हमारे बच्चों को जब भी आवश्यकता पड़ेगी, आप समय देते रहेंगे। इसी तरीके से आपकी कृपा बनी रहे और आप जो आज कुछ अपने लेक्चर डिलीवर करेंगे, हमारे बच्चे अवश्य उससे आप लाभान्वित होंगे। बहुत बहुत अंत में एक बार पुनः जो है धन्यवाद, स्वागत, वेलकम, आभार समय देने के लिए सभी जूरिस्ट को। थैंक यू वेरी मच।
Thank you, sir. Thank you very much, sir.
Thank you so much, sir. Thank you so much, sir. Nothing would have been possible without your constant support and guidance, and we are very thankful for you for that. Our second speaker for today is the very inspiring and passionate Ms. Interim, the Director of Indian Institute of Arbitration and Mediation and Executive Director of Asia Pacific Center for Arbitration and Mediation. She has undergone training and has been associated with the best legal educational institutions in the world. Some of them being Chartered Institute of Arbitration UK and the Harvard Law School for Advanced Mediation Program on Negotiation in Harvard Law School. Having won many prestigious accolades for her distinguished work in numerous capacities, she is truly an inspiration for all of us. I would please request Ms. Majid to kindly grace the audience with her insightful words. Over to you, ma'am.
Thank you so much, Iftida, for the warm welcome. And I would like to say thanks to Vinita ma'am, Professor C.P. Singh sir. And I would like to say here that Vinita ma'am and me starting talking on this event only. And before that, I never knew her. And I would like to say thanks, like the way she approached, the way she was talking about the students. She said that, ma'am, हम चाहते हैं कि हमारे यहाँ के स्टूडेंट्स को आप जैसे लोग आएं और उनको बताएं कि व्हाट इज एडीआर एंड वी वांट के वो लोग भी आगे जाएं और बहुत कुछ करें. द वे शी अप्रोच एंड द कंसर्न अबाउट द स्टूडेंट्स, it's not easily see, you people are blessed. I must say that you people are blessed being into this college under the leadership of Vinita ma'am and CP Singh sir. So, and I know that today it's a Sunday and a lunchtime and my session. I'm so sorry for taking you with me, and I'll try to give you a kind of, a session which will be very fruitful for you and which will take you to the different level of this ADR. I'll try to do the justice with my session because I know it's the lunchtime and a Sunday.
Oh, no, ma'am, we are eagerly waiting for your talk.
No, ma'am, मैं सच बता रही हूँ, ma'am. The way CP Singh sir said, now the thanks to everybody. जिस तरह से उन्होंने बोला, ये करा, ma'am, students को यही चाहिए. Students want that the teachers and the dean and the faculty members should be like that. And अगर ये दे देते हैं हम, तो we are giving the pizza. See, what a institute can give, what a university can give. They provide a base to the student. That if you see the pizza base, उस पर topping students ने लगानी है. what we are giving a beautiful base to all the students with having all the ingredients into it. And now it's up to the students ke wo us pe kya topping dalte hain and how they are going to customize their pizza for the more healthy and the useful for them, for themselves. So this is what we can do. So after thanks to Harjot, he has been delivered a very beautiful lecture about the recent upcoming topics of the arbitration, like Section 9, Section 11, and recent developed judgment of the Amazon judgment and all. And my co-panelist, Mr. Manish Malhotra, and my another co-panelist. So see, I can say that ADR is a very upcoming and developing area in the field of ADR. It's so rising day by day, and the growth is very significant. And there are genuine opportunity for all the lawyers and the students and to become an arbitrator and mediator with their experience and expertise. And as a professional consultant or the lawyer, you need to adapt the demand of this subject. You need to demand the sophistication of this subject. You need to demand, you need to adapt the demand of the corporate client and what this world wants from you. So you need to adapt all those practices, all those skills, and enhance your knowledge and your capabilities to become an arbitrator and mediator. See, I must say that this subject is very new, and this subject is a very upcoming topic. And the colleges before I must say 2018, the colleges were pro litigation, pro adversarial system, but now all the colleges are giving stress on the mediation and the ADR mechanism. And so it is a developing field. And I must tell you that if you be reading the contracts or you will be reading any commercial disputes and all, 70% disputes will be dealing with the ADR or the ADR mechanism. If you talk about the US system, 3% cases is being handled by litigation, and 97% cases are resolved through ADR, through arbitration and mediation. For them, this ADR is the first choice for resolve their dispute, and litigation is the second choice for them. So this is what we are looking for. So before starting it, see, my introduction is being given by Ibtida and Vinita ma'am and CP Singh sir. So before that, I should tell you about me, that from where I come and how I have been landed into this profession. See, I used to be very shy and very timid person, and I belong to a very small place, Aligarh. And I never been into any internships and all. And I came to Delhi only with my certificate, with my mark sheet, and that was in my hand. And I thought, ke Baba, hum to topper hain, kuch bhi kar lenge. I landed up into a chamber in Delhi High Court and said, Madam, this is my mark sheet and I am a topper and I want to work with you. Having no idea that everybody will ask you that how previously your like आपने कहाँ internships कर रखी हैं पहले, how is your previous experience, and about your profile, CV, everything. No idea about it. And that was the first time I landed into the Delhi High Court premise, and I was no bar council registration, nothing. See, this is what we feel once we are inside the campus, inside the college. We are having a lot of pampered friend, who give you jugaad bazi and all, and the teachers who pampered you a lot. But the moment you will be out from this premises, out from the gate, see, life is not so simple. Life is very, very difficult. Your friends become your opponent and the competitor. So you have to compete with those people. There is no friend like that. All people are your competitor. Your seniors sometimes will also be jealous. Like your teachers are the people who promote you, and they will be feel good whenever you will be doing any success in your life. But sometimes your senior will be sometimes your competitor also in this field. So hum chale gaye the apni mark sheet lekar. Then she was very kind enough to understand my innocence at that time and my ignorance about not preparing my CVs and everything. And she said, okay, you can come from tomorrow. And I started my work over there. And I started court practice over there. I started reading files, take over all the responsibility, whatever I can do in that chamber. And even now, if you see that now I'm having a lot of reported judgment after that, because I did not hesitate to take any work, whatever work she granted to me, कि हम ये कर दो, ये कर दो, ये कर दो, okay ma'am, blindly follow her, and I follow her each and every step, and I got into this litigation, very aggressively into the litigation. And after seeing my performance, the court was very happy with me. The judges were used to be very happy with me. And in first 3 years of my practice, I got my first arbitration from the court referral. A judge named Justice Pradeep Nandarajog, he was retired from Chief Justice of Bombay High Court. He gave me my first career arbitration that time. उन्होंने कहा इरम आप इसको arbitrate करिए matter को. So that is how I got into this arbitration. And if you talk about the mediation, so I'm doing arbitration and mediation both, but mediation is more close to my heart. Why? Because when I got into this mediation, and I got a first case of my mediation as was doing a mediation, the party who were into there, they came for the mediation, and the dispute was pending for last 25 years. There was a matrimonial dispute, husband and wife dispute, and husband has got a divorce decree against his wife, and wife filed an stay, and the case for the there's a stay case was been pending for last 25 years. When they separated, they are having 2 kids, 1 year and 2 year. And when the mother used to come before me in the mediation, they were around 23 and 25 years of age, and they are about to marry. And that case gives me a kind of, completely change my psychology. कि यार हम लोग क्या कर रहे हैं? The person wants to get divorced, and we are not being able to give him divorce timely. The entire life is being spoiled. This is the system. Is this the access to justice? No. And that day I thought that I should do hard work into this ADR field. And I must say that ADR, I did not choose ADR, but ADR has chosen me somehow, and it came into a full platter to me. And that is how I landed up into and have my interest into this ADR practice. And if you talk about the arbitration, so arbitration is like first act came into 1899. Thereafter, the second act came in 1940. And 1940 act was having lot of loopholes, because that is not something which is being done by Indian people. It is being adopted by English Arbitration Act. And thereafter, after this model law, we come up with 1996 Act. That is a beautiful cut, copy, paste work of unilateral model law. I must say that. And it was again have a lot of loopholes. See, if you see the history of Arbitration Act, there are a lot of acts, lot of amendments, and even we are into, like Harjot was saying, that we have deleted the Schedule 8 and adopting the Schedule 8 and whatever it is. Like there are a lot of things which we keep on doing, changing. Why? Because the committee in which the law is, the drafting committee is not having the people who are trained into arbitration, who are expert into arbitration. They sit and they cut and copy paste of the provisions, which is not even, they are not friendly to India. They're not friendly. See, we are very good exporter of problems. We export our problem to SEAC, we export our problem to HKIAC, we export our problem to Malaysia, but we don't have a solid mechanism, just because we fail to have expert people into the committee. And recently this 2015, after 1996, 2015 amendment came. 2015 amendment, मैं आपको बता दूं, it was a beautiful amendment and based on Justice AP Shah's report. And they come up के इस तरह के changes होने चाहिए. तो वो changes, after that changes, again we need to have a change in 2019. And 2019 amendment that brought, the Schedule 8, they talk about the qualification of arbitrator. The qualification was 10 years. So आज जो student law कर रहा है, and if they want to become an arbitrator, for them the 10 years was like the qualification. So parliamentary committee, before notifying this 2019 amendment, they made they made a parliamentary committee of 17 parliamentarian members. I was one of the person who's been called for the recommendation, and I went there in Mumbai 2020 January. The meeting was held. हम लोग वहां गए, हमने उनको बताया Schedule 8 should be omitted. It should not be there. And we also gave them certain other things like we talk about ICA and all. So a lot of things that will be too technical for you, but we were there from the IEM. I was there. I made certain recommendation, and after that this schedule 8 is been omitted from there. So now other things is also been there, like after 2019 amendment, there will be a formation of ICA, Indian Council of Arbitration. That will be also in now being in the time being, it will be formed after some time. So people are working on that. So this is all about little bit history of ADR, of our arbitration. But now talk about for your level, like from your perspective. I have seen that the colleges are teaching arbitration either in the 4th year or either in the final year. Many of the students, they are approaching me, they're saying, ma'am, हम तो बहुत लेट हो गए स्टार्ट करने के लिए, हमने आज तक कहीं इंटर्नशिप नहीं करी. Now how we will be if we want to choose this as a career, what things we are having as of now. So उनके लिए, for the students from the 1st year till 5th year, I'll be telling you that how you can enhance your skill, how you can enhance your opportunities into this. And many of you may try to be into this profession. So I must tell you that this is the future. This is the future. अगर आपने अपने आप को कुछ बनाना है, see, I in such a small time, I've been known into international community. I won the awards, and now I'm working with the United Nations. So why you can't? Such a timid person who came from Aligarh and went till Harvard and now working with UN. So आप क्यों नहीं कर सकते? You are having all the infrastructure. You are having the social media power. You are having such a beautiful backup from your colleges. So we were not having that. I told you that I was not having anything in my hand except my mark sheet. So now you are more privileged, and I expect all of you that you will be doing wonders into this field. And whenever you will be needing a kind of any help, I am always there for the students. So now let's start how and what skills you will be needing for doing or to enhance your skills into arbitration or mediation, whatever I'm talking about jointly for the IDR. The first and foremost thing is start internships. So internships कहाँ करनी है, कैसे करनी है और कहाँ कितने दिन तक के लिए करनी है. That is very, very important for you. So the internship is like you should start internship with certain centers, institutes. Like in Delhi, we are having Delhi International Arbitration Center. I am also having a center that is called Indian Institute of Arbitration and Mediation Center, and now APCAM Center, Asia Pacific Center for Arbitration and Mediation. So you should do your internship with certain institutions. Otherwise, you should do your internship with, there is one or more center that is called Nani Palkiwal. They also provide the internship opportunities for the students. So you can join those institutions like Nani Palkiwal Institution, IIM Institution, or Mumbai में एक institution है, Mumbai Arbitration Center, or you can join SIAC even SIAC is giving the opportunity for internship for the students. Many students, they ask me for writing the reference letter to the SIAC, and they give 6 months or 5 months or 3 months opportunity accordingly to the students to go to the internships. Either you can join a lawyer who is doing arbitration matters. तो आप उसको join कर सकते हैं, the person who is doing the arbitration matters and all, because see, arbitration is further crystallized into different like investment arbitration, maritime arbitration, sports arbitration, and so on. So once you will be doing internship under the person who are expert into arbitration lawyers and arbitration field, then you will come to know a vast sea. How vast sea? This act seems to be very technical and very small, but I must tell you it's very vast once you will be try to dive into it. So ADR अपने आप में एक different world है, अपने आप में एक नया passion है, और अपने आप में एक नई दुनिया है, बिल्कुल अपने आप में. So that is how you should do your internships, and for that start now. If you are in final year, don't wait, start now. If you want to adopt this as a career, see, एक और बात मैं कहना चाहूंगी. Many of you want to go into judiciary, many of you want to go into teaching, and many of you may want to go into different fields like the criminal and all. So for them, I always say one thing, that whatever is your passion, chase that. Whatever is your passion, chase that. Whatever is your dream, try to chase that. Otherwise, the work will be very boresome and very boredom for you. Why I am very happy doing ADR and practicing into ADR, because this is my passion. It is in my blood and in my veins. And I always think like an ADR professional in every field. So that is something which is very important for you to select what kind of internships you are going for. Second thing is, don't feel that if suppose CPC and Evidence Act is not applicable to it, so you don't need to know the court crafts. Court crafts is very, very important, because once you will be going for the enforcement and all, or if you will be going for Section 9, if you will be going for other aspects for the arbitration, and if you are going for the challenge the arbitral award, for that you need to know the court crafts as well. Second thing, what you need to read. So there are a lot of books, and before that book, I would like to recommend you to read your Bear Act. That is a Bible for you. That should be a Bible for you. So read the Bear Act, and always, those who wants to enhance their skill, always keep the Bear Act nearby you. ठीक है, Bear Act को हमें पढ़ना है. Thereafter, you should go to the report of Justice A.P. Shah's report. That is having a genesis of 2015 amendment. Justice A.P. Shah's report is beautiful and conclusive. And those who don't have that, please mail me or LinkedIn me. I'll send you right away, because I'm reading that reports when I'm delivering the trainings and the lectures and that. Then you should read the Justice B.N. Krishna report. That is having the genesis for 2019 amendment. So Justice B.N. Krishna reports is very, very important to go through and to 1940 is being redundant, and then in 1916, then 2015 amendment, 2019 amendment. It will give you a conclusive idea about the entire arbitration. After that, you should read the UNCITRAL model law. I told you that Indian Arbitration Act is completely based on UNCITRAL model law. Even the provisions are somehow similar. So read UNCITRAL model law, read UNCITRAL model rules. For that, you need to go to www.uncitral.org. That's a website you can go through, and you can download the act, you can download the rules. Thereafter, there are soft laws. Soft laws like IBA guidelines, what IBA guidelines says, how to conduct evidence, Prague guidelines, CIAC rules, HKIAC rules. They are beautiful rules. ICC rules. Now ICC are amending their rules related to online, shifting online, because now we don't have the provision in the act, but if we are going to do online arbitration, so for that we use the guidelines. So UNCITRAL has provided the guidelines for ODR, and Seoul is also provide the guidelines for ODR. ICC also provide the guidelines for ODR. So if you are going through attached with some lawyers and all, go through these guidelines and soft laws. Thereafter, I would like to recommend you certain books. The books are, if you want to know about the domestic arbitration, you should read Markanda Step by Step. It's a beautiful book, Markanda Step by Step. If you want to read the international authors, I will recommend you Redfern Hunter. Redfern Hunter, again, a beautiful book, and Gary Bond. You should read the Gary Bond. You should read Margaret L. Moses. This is the Cambridge University edition publication. Margaret L. Moses. If you want anything more, I can also send you these books and all. Other thing is Moot. Mediation competitions or arbitration competition. Though we don't have arbitration competition much in India, but there are international competitions that like Vienna, Viz Vienna, Hong Kong, Vienna. We are having this kind of competition. You should participate into that competition. ICC mediation competition is one of the best competition in the world. And I have been an occasion to judge this competition and went to Paris 3 times as of now. And I've been judging these competitions. I went to Vienna also. I went to Hong Kong for judging the arbitration competitions. And I must tell you why this competition is important. Because you are not only preparing the drafts, memorials, but you are arguing there. And moreover, try arguing and preparation. There is a thing called connection, network. See, your work is more important than your network is more important than your work. So what you built over there in these moods, you build a beautiful network. See, all the professional entire world, either they are from A to Z, they will be there. You will be having an opportunity to meet them. You can go as a volunteer. You can go as an observer over there. And if you suppose you are not going to participate, but you should go and meet people over there, because there is a purpose of all the people to be there, because they are the like-minded people. So once you will be in the like-minded people, then you will be having a circle and a network, and that network will speaks volume for you. वो नेटवर्क ही काम आना है, हमारा नेटवर्क हमारे वर्क से ज्यादा इंपॉर्टेंट होता है, ये हमेशा याद रखिएगा. And for that, if suppose the students who are not having the LinkedIn account, please prepare and make a LinkedIn account today. And your first request should be to me, because in that you will be making the circle. आज आप अपना विजिटिंग कार्ड या अपने बारे में आप किसी को नहीं बता सकते हो जाके बार बार, बट लिंक्डइन अकाउंट इज अ professional platform and foundation that will be building your, and it will be bringing all the people जिनको जो आप चाहते हो हमारे नेटवर्क में आए, and all the people will be with you, and you keep on posting, keep on writing, blogging, articles and everything. See, that will give you an edge today. If you want to create your network नहीं है, LinkedIn account नहीं है, तो you have no identity. That is your identity. I must say LinkedIn account is your identity. If you don't have that, so I'm sorry to say you don't have any identity. And your network work more than your work. That will speak for you. So always have a LinkedIn account and add the people you want to be. Like somebody wants to be go on the criminal side, they add the criminal people into this. If you want to go into ADR field, add the ADR people into that. This is all about the other things, the attributes which you need to have, and accreditations and everything. So many students, they come to me, ma'am, which training we should need it for arbitration? What kind of trainings for the mediation? See, I must tell you that no training, that suppose you are going to attend a training for any certificate, don't do that. Don't do that. If you are going to establish yourself in the international field, see, arbitration is the only field which gives you a platform to practice internationally. No criminal law, no civil law, no other law will going to give you that platform. Why? I tell you why. Because in entire world, we are having 197 countries. 197 countries. And 166 countries has signed the New York Convention. New York Convention is a convention which is for the enforcement of settlement, enforcement of award. So in out of 166 countries, if आपने arbitration में practice करते हैं, तो आप 166 countries में आप कर सकते हैं practice. कोई आपको रोकने वाला नहीं है. And the fee, you want to know the fee? See, in one Yokas case in Russia, the fee was given to the client, and the client for the response for the claimant 50 million US dollar, and the respondent got 35 million US dollar. And I am doing one case in mediation from the ICC Paris, and I will not quote the fee, but that is also some million, some US dollars, some good US dollars. So fees ka bhi wo nahi hai. But the only thing what the international standard is accreditation. So what is accreditation you are having today? आप training तो आप कर लेते हो, but हम लोगों को ये इंडिया में पता ही नहीं है what is accreditation. So accreditation is when you will be doing some good certified training programs. After that, that institution will give you accreditations. So in India, now I would like to tell you, in India, we have formed an institution that is called Asia Pacific Center for Arbitration and Mediation. That is for the very first time in entire world, a history create hui hai, jisse ke now all the country in the Asia will be having a center of AppCam center हर जगह पर होगा, and the person who will be impaneled with one center will be impaneled with all the countries of the AppCam, all the countries. And this is something, the secretariat is in my office and the head office in India, and it is for the, it is like when I was talking with the Ministry of Corporate Affairs people, they said, ma'am, this is an honor for India that we are having an institution like SIAC and other places. Like why Amazon case is being into SIAC, because we don't have the provisions into in India. But now after this Asia Pacific Center and IAM Center, we are trying to give the rules that will be helpful for the community, and we need not to go anywhere outside. We will resolve our dispute in India as well, India only. So these are the things. And suppose if you want to do mediation training, so always remember that do always 40 hours training, because 40 hours training by the Supreme Court is being mandatory. So always understand that what we need to do is we need to have a good internship. We need to have a good books to read. We need to have these LinkedIn accounts and connections, and we should go to the mooting and all. We should be doing trainings which will give you the accreditation and which will give you some sort of certification. It's not a piece of paper. It is useless for you. It is useless for you. And another thing which is very, very important for you is like to know about some soft laws like TPA, contract, Sales of Goods Act. See, you need to read this, because this will be helpful, because these are substantive law. This will help you in going ahead into the arbitration. Without this, arbitration could not be performed. So these are the basic things which from my side, I feel that you should take it, imbibe it. And certain thing for the colleges, that colleges should provide the search engines to the like the Clover and other platforms to the students. Colleges should organize these kind of webinars and seminars, so that, you know, if I'll be able to inspire one student in my one webinar, I am successful. If one webinar and one seminar will change at least 4 or 5 students, and they give them the purpose of their life, that what they want to do, inculcate a kind of, you know, something into their brain and mind. So that is successful webinar, according to me. That is successful webinar. मेरी कोशिश ये रहती है कि मैं अपनी लाइफ के बारे में बताऊं, and I will tell you that from where I started and from to where I am now. तो आप लोग भी कर सकते हैं, and college and the student has to be together in this, together. And not only this, but you should also, the college should also provide, you know, the trainings, these kind of trainings which I'm talking about, the certified trainings and the certificate course, or the accreditations provide. Because these days I am talking with National Law University Bangalore, National Law University Delhi, and Jagran College in Bhopal, and other universities regarding this kind of trainings. We are providing this kind of training to the students, and I know that how the students are coming and they are saying, ma'am, we want to do something in ADR, and they are very, very happy after you know, having all these things. And in the last, I would like to say one thing, that select a mentor. Do select a mentor, because that will help you a lot, See, I was not having a mentor, and for that reason, I've been roaming here and there, like litigation और ये वो. बहुत देर से समझ में आया कि ADR मेरे लिए बहुत अच्छा है. So from today onwards, if you have a edge on certain thing, if you want to do certain thing, so please have a mentor. And I want mine to help you, because I am running lot of groups for the student, for the youth ADR and all. And any help if you want in your life, not only in ADR, whatever. I considered me as your senior, considered me as your elder sister, or whatever you want. And I am always there for you. And I would like to end, because Vinita ma'am is looking at me, I can understand that. See, once I start, it is very difficult for me to stop, but I would like to end with one beautiful story about, for all of you. This story is dedicated to all my students who are listening me passionately on the Sunday afternoon lunchtime, I can understand. So, एक बच्चा था और उसके फादर थे, मदर नहीं थी, उनकी मदर की डेथ हो गई थी. तो फादर जो थे वो अपने बच्चे को बहुत ज्यादा प्यार करते थे. उन्होंने कभी अपने बच्चे को स्कोल्ड नहीं किया था, कभी डांटा नहीं था, कभी भी कुछ उससे, क्योंकि वो मदर नहीं थी उसको बहुत पैम्पर करते थे वो. उनके पास एक वर्ल्ड मैप था, बहुत ही ब्यूटीफुल. एक दिन बच्चे ने वो फाड़ दिया, एंड फादर ने उसको एक स्लैप किया दैट डे. तो बच्चा बहुत, ही वाज 7 years of age, 7 or 8. उसको बहुत बुरा लगा. उसने कहा, मेरे पापा ने मुझे आज तक कभी डांटा नहीं, कभी ऊंची आवाज में बात नहीं करी. आज मेरे पापा ने ये क्या कर दिया, मुझे कैसे थप्पड़ मार दिया, मुझे चांटा कैसे मार दिया. तो वो बहुत परेशान था. एंड फादर ने कहा कि ठीक है, मैं ऑफिस जा रहा हूँ. द मोमेंट आई विल कम, आई वांट दिस मैप टू बी इन ऑर्डर, दिस मैप टू बी इन ऑर्डर एज इट वाज अर्लियर. फादर चले गए. जब वो घर वापस आते हैं तो मैप उसी तरीके से, उसी जगह पे वैसे ही लगा हुआ था, सेम वे. तो पापा ने बच्चे को बुलाया, बोले कि भाई ये मैप कैसे सही हो गया. उसने कहा, पापा मैंने जोड़ दिया. उसने कहा कि बट तुमको ज्योग्राफी आती थी. उसने कहा नहीं. तुमको लोकेशंस पता थे कि कहाँ पे कौन सी जगह लगनी है कि नहीं. फिर तुमने कैसे जोड़ दिया, ये तो बहुत डिफिकल्ट है, कहाँ पे एशिया, कहाँ अफ्रीका, कहाँ नॉर्थ अमेरिका, कहाँ अमेरिका, कहाँ ग्रीनलैंड, सब तुमने कैसे लगा दिया. उसने कहा, पापा इस मैप के पीछे ना, देयर वाज अ फेसेस ऑफ ह्यूमन बीइंग. इस मैप के पीछे इंसानों के फेस थे, मैंने सिर्फ वो फेस मैच करे और वर्ल्ड मैप अपने आप बन गया. This is what ADR is. We build people, we build each other. और जब मैं ये बताती हूँ तो I get goosebumps, because see, the work we are doing is, see, a lot of people are doing cases, but you have to contribute into this field. Then only you will be a leader. To lead, you have to contribute, and I am contributing into this field. See, I'm making, I'm adopting villages. इसमें के dispute free villages बना रहे हैं. I'm mentoring students because students are the future. उन्हीं ने करना है सब कुछ. आप ही ने करना है और आप ही लोग करोगे अपने लिए. और you need to have a why in your life. जब भी कुछ करो हमेशा क्रिएट कर लो एक why कि मुझे क्यों करना है ये. अगर वो why WHY तुम्हारी जिंदगी में नहीं है, it will be very difficult for you to do anything. So before taking any work in your hand, before challenging, before selecting any option, career option, please select why for that. अगर नहीं है तो create कर लो एक why आज से अपना and build each other. This is what the ADR and mediation talks about, building each other. हम एक दूसरे को बनाएंगे. So that is from my side, ma'am. Thank you very much for listening me patiently. And I could speak more, but my time is not there. Thank you very much.
Thank you. Thank you so much, ma'am. Your distinct vision makes you nothing less than an idol of knowledge and experience, and you're very inspired and grateful to have you today with us. The third speaker for today, Mr. Manish Mehrotra, is a senior practicing lawyer in Lucknow with specialization in arbitration law and commercial business litigation for the last 28 years. He has appeared as a senior lead counsel in more than 130 arbitration cases on behalf of several corporate clients all over India. Mr. Mehrotra has had the credit of participating as the keynote speaker on the subjects of alternative dispute resolution and with justice for various training sessions and courses. He has also been a notable speaker for various seminars and programs organized in arbitration law since the last 2 decades. Sir, I would please request you to guide us through the nuances of international arbitration.
Thank you.
Over to you, sir. Thank you.
A very good afternoon to all of you. First of all, I would like to thank Honorable the Vice Chancellor, Professor Vinita Kacharji, Professor C.P. Singh, for giving me this opportunity to share my views with the young minds. I must tell you that this is one of the best things which I like, that when you are interacting with the new, fresh mind, the value system, you are contributing to the value system of the society, where you are actually aiding the budding lawyers. And it is a pleasure for me to be with all of you today. Today, the task which I want to do, I'll try to make it simplified so that the lawyering language is not there for the young students. And today's topic is very, very interesting because this entire program is based on ADR. But you see, the confluence is the relationship between the courts and the ADR. Until and unless the courts extend a helping hand, the ADR system will really not be encouraged. And I'm happy to say that the legislative history of this country reflects largely upon the vision, the policy vision which the government, which the courts have all tried to incorporate, that here we need to encourage ADR. And that is why today's topic, on which I'm going to briefly narrate a few instances, is very important. Because once the ADR process is setting and the arbitration proceeds and the award is rendered, what happens to that award or that judgment in the courts is of paramount importance to actually, which gives a characteristic of life, or there is some kind of bottleneck in the encouragement of ADR in the country. So before I start on the topic, I would like to briefly tell you that in 2016, the government of India, they organized an international conference on arbitration in New Delhi. And I was fortunate to participate. We had speakers from all over the world. The Chief Justice of the Singapore Supreme Court and so many other dignitaries were there. The program was inaugurated by the President of India. The Prime Minister spoke, the Chief Justice of India, Honorable Supreme Court judges. But the best part which I learned in that conference, which I learned as a student of law, was that there was a consensus on encouraging ADR in India, making India a hub, a global hub for arbitration. Now, that philosophy is very nice, but to give effect to that philosophy, you need to understand that what is the legal position, how are the laws framed in the country, whether in the form of statute law or case law. Now, these, I would like, obviously all law students by now would have understood this, that these are the two main streams which give you the effect of the legal position. One is the statute law and the other is the case law. Now, when we talk of statute law, the arbitration history in our country is very old, but 1940 was the first codified law in this country wherein the arbitration procedure was encouraged. Now, after that, lot of problems took place in the 1940 Act working. In fact, there is a very famous judgment of the Honorable Supreme Court in the year 1981, wherein it has been said by the Supreme Court that unfortunately, the manner in which courts have started interfering in arbitration matters, the lawyers are laughing and the legal philosophers are weeping. I mean, so the entire purpose had been defeated. So thereafter, we adopted the ancestral model law, wherein the 1996 came into effect. But whenever a law is framed, it has its sets of problems. When it comes to the ground reality in the courts of law or in arbitration process, you find that there are a lot of loopholes which have to be plugged in. So 1996 Act also had a lot of problems. So therefore, 2015 amendment came, which carried out some very drastic amendments. Then 2015 also was felt that it is not perhaps fulfilling the requirements what are expected to encourage ADR. So 2019 amendment came. So I'll be briefly touching in a very, very simple way to tell you this is the broad contour of the subject which we are now going to delve. So my topic here today is about the scope of interference in the awards. So obviously when we talk of interference, the necessary sine qua non is that you are talking about the first relationship which is established between the award, that is the judgment passed by an arbitral tribunal, whether when it is a situation of enforcement of an award in the international award or a domestic tribunal award. But that is the starting point where for the first time, the psyche, the philosophy of law, insofar as courts are concerned, that is the starting point. So when we talk of that, yesterday I had attended the inaugural session, and Justice Thakur, who gave his address, there are 2-3 things which I think were very, very fundamental issues which he raised. First thing which he said was that judicial support is needed for the awards. Now that is something which is very, very important. Second, he said that for encouraging ADRs, we must understand that the courts are overstressed. Now that is another important aspect, that it is an alternative dispute resolution mechanism. Now it has come, according to me, the word alternative is losing its significance with passage of time. I say that it is an alternative because the regular courts are the main structure in the judicial hierarchy in our country. But the way I look at arbitration, that it is the future of the dispute resolution mechanism in the entire world. What to say of India? And India, according to me, must become a global leader in this dispute resolution mechanism, because the era of ADR, I mean the era of alternative, is gradually, the dividing line is becoming very, very thin. It is virtually now a parallel legal system, and a very, very successful parallel legal system, which is playing a very, very dominant and key role in the dispensation and the adjudication of the disputes between so many parties, and especially the commercial matters, everybody is now opting for the mechanism by the process of arbitration. Justice Thakur also emphasized that despite the fact that the grounds of challenge in an arbitration award are very limited, but still the courts are flooded with litigation. Now, I'll be touching on that topic a little ahead in my talk, but that is a very important limb to be understood by all of us, that the approach with which the court sees an award is of paramount importance, and which, according to me, it is the duty of all lawyers and everybody who is associated with this alternative dispute resolution mechanism to put forward your point of view before the court, that the tribunal has to be encouraged, and how the law has to, until unless that law is developed with the cooperation of the court, it will be very, very difficult to really give shape to the purpose and essence of arbitration. Because the legislature may make laws, but ultimately the laws are practically implemented by the courts of law, and therefore the role of the courts, that is when we talk of today's topic, the supervisory role of the courts, come into a very, very strong play. Now, we must understand that how the courts have dealt with it. So when we had this 1940 Act, now I would invite your attention to this, that when 1940 Act was there, the moment an award or a judgment of the arbitrator is pronounced, the party who is aggrieved by that award has a right to challenge it in the court. And that challenge had the grounds which were there. There were three broad grounds under the 1940 Act. One was that the arbitrator has misconducted himself or the proceedings. The second one was that the award has been improperly procured. And the third ground was very, very broad in its canvas, that any award which is otherwise invalid. So coming into this three broad parameters, the upshot of the real facts were that virtually after the pronouncement of award, a regular appeal was filed in the courts, and any amount of disputes could have been raised, and the matters lingered on and on and on in the courts like any ordinary civil suit. So therefore, hardly that spirit of the alternative dispute resolution mechanism was being seen on the ground realities as well as the reality of the litigation is concerned. It was being dealt with as if it is an appeal from any other regular court of law. But a lot of problems, the courts, the honorable high courts, the honorable Supreme Court, it became flooded with litigation. And at a drop of a hat, the parties used to obstruct the process of arbitration by rushing to the court in between at various stages. So they first misuse the positions of law, the provisions of law, to see that the arbitration proceedings do not settle down and not decided. And I must share with you with some amount of pain that even in my career as a lawyer, I have seen two arbitrations which have lingered for 25 years. Now, can you imagine that the ordinary civil suit, if you go into a regular court, if you file a regular case, people dread going to court because they feel that the litigation is going to go on and on and on. But the same story I saw as a lawyer in two arbitrations where for some pretext or the other, the one party or the other tried to create some legal complication, and the litigation lingered for 25 years before the award could be pronounced. So the entire purpose of the alternative dispute mechanism collapsed. The other aspect is this, that all these mischiefs, all these problems were realized by the legislature, and then India aspired that they should come in consonance with the world arbitration matters and the world mechanism of the alternative dispute resolution mechanism. So therefore the 1996 Act came. Now let us see that what changed materially insofar as the courts are concerned, insofar as the role of courts are concerned under the 1996 Act is concerned. The first major change was that the legislature had to provide a specific provision, which is Section 5. Now, that section is normally missed by the people, but according to me, it is the philosophy of the Arbitration Act that Section 5, it describes and defines that there shall be no judicial intervention except as provided in the Act. So this is a provision which excludes the jurisdiction of the courts. It gives the primacy to the arbitration proceedings and says that it is not in any and every situation that the party will be allowed to rush to court. You have to first finish off the arbitration proceedings, and only in the manner in which the interference of the courts is required, insofar as the arbitration matters are concerned, only in those situations a party can approach the court. So what good did this do to the arbitration law? The first good and the main good which it did, that the arbitration proceedings, it is started concluding without any hindrance. The second aspect of the matter is that Section 9 is a provision which gives the courts the power to grant any interim relief. But the legislature in its wisdom also added a parallel provision, that is Section 17 in the Arbitration Act, wherein the balancing act was that some even interim relief which you can actually pray for from the arbitrator, you need not rush to court. And then the third stage of court's role, which comes in the arbitration law, is Section 34 and Section 48 in the case of international arbitration, where enforcements can be refused on certain grounds, which are quite similar, but with a minimalistic interference, even as far as Section 34 is concerned. But still, the law of interference of the courts in the awards of the arbitrator remains by and large similar. And now the new grounds were now limited. So as we saw that in the 1940 Act, virtually you could raise any ground on earth to challenge the award, but no, now Section 34 in the 1996 Act, the legislature said, no, you have to make out a real case on these limited grounds where you can actually disturb the findings which have been recorded by the arbitrator. Now, first thing is that law is very clear that the court does not sit in appeal on the award. So one thing is very clear, that it is not an appellate power which is exercised insofar as this petition under Section 34 is concerned, much less to say about Section 48 in the case of international awards. The other main ground is that you have to say and satisfy the court that the arbitrator did not have jurisdiction, meaning thereby that he is trying to decide a case which he could not, or he is trying to decide which is a case which is beyond the terms of the reference or the submission to him. The other aspect is natural justice, that if you can make out a case that, look here, I failed to get my opportunity to present my case before the arbitrator, that is another ground on which the courts can say and start interfering in the award. And third, and the fourth point is very important. It is the area where, again, I will tell you that how law developed and what difficulties arose. And all these are stark evidences to show that now arbitration law has come to stay in the world, I would say. And India being one of the finest leaders now in the arbitration law, because there is a consistent support by the honorable courts, of the honorable high courts and of the honorable Supreme Court of India, insofar as the stature which has been accorded to the arbitral tribunals or the process of arbitration and alternative dispute mechanism. The next ground is public policy. Now, public policy became a matter of great debate. For the first time, the public policy, the lawyers, when they challenged the awards in the court, the lawyers started out to interpret the term public policy in various dimensions. They started arguing that anything, well, if the arbitrator has missed this, this is also against public policy. If he has missed the legal provisions, that is also against public policy. And then came in the year 2003, a very famous judgment of the ONGC versus Saw Pipes case, in which it was pronounced by it was laid down by the Honorable Apex Court that this term public policy has to be given a wider perspective or a wider meaning. Now, the purpose was very clear. See, 1940, the courts had all the independence to interfere in the arbitral awards. Of course, from 1924 onward, there are certain decisions which laid down certain principles like that the arbitrator shall be the sole judge of the quality and quantity of evidence, and that he has full jurisdiction to interpret the contract. All these laws are still intact, but on ground reality, in pragmatic, litigation, which I can tell you as a lawyer, on specializing in arbitration for so many years, that became a practical reality, that the interference level of the courts had actually prolonged, it had increased, and there was a lot of window to set aside an award. So 1996 tried to close that window, or in fact, close is the wrong word, it tried to limit that window, but Saw's case again tried to expand the horizon by laying down that no, public policy means that it has to be given an interpretation. The purpose was that sometimes lot of injustices were done in the process of arbitration, and obviously you needed a mechanism to get it corrected in the court. And what was the mechanism available? That the other side would always argue that, see, if the case is not following within the parameters of the grounds of challenge under section 34, so therefore this petition is not maintainable. So to avoid that injustice, the public policy was expanded. But again, the moment Supreme Court expanded public policy, there was a flood of litigation and the interference level started. Now the legislature realized that in the garb of the public policy, again, the problems which we were facing in the arbitration to give finality or to give strength to the alternative dispute resolution mechanism is again collapsing by various interpretations of the courts, that this is public policy, so therefore it is bad, that is not public policy, so therefore it is not bad. So a floodgate opened. So in 2015, they amended the 1996 again, and they limited the concept of the word public policy to restrict the wider interpretation which was given by the Supreme Court in the matter of ONGC versus Saw Pipes. And they said that, well, public policy meant that it means only for the violation of fundamental laws of India. Now, fundamental laws of India are the straight principles, so don't try to over-interpret public policy. This was the message which the legislature gave. But again, some of the judgments came where the word public policy was again interpreted, and the Honorable Apex Court, in a very, very leading judgment of Associated Builders versus DDA, which in the year 2015, it is one of the classic judgments of the Supreme Court, which everybody must read. Two judgments of Honorable Justice Nariman, that here the public policy was interpreted in the manner in which the legislature intended in the 2015 amendment. And it said that perversity and patent illegality are also grounds of challenge under the term of public policy. Now, what is perversity? Perversity, the court interpreted that even though it is not specifically mentioned as a ground in the act, but the award will be considered to be perverse if the arbitrator has just ignored the evidence which has been brought on record of the case, or the arbitrator sees the evidence but uh, ignores the relevant and includes the irrelevant, or the arbitrator only applies the irrelevant but ignores the relevant. So lot of in scenario was there. So the Honorable Supreme Court tried to put it in concise frame and said that no, perversity will also be a ground which will include these things, meaning thereby that again a little bit of expansion was given to the concept of public policy, which was originally there in the case of ONGC versus SAW pipes. And so there you can see that there is a constant, I would not use the word tussle, but a constant debate going on between the law which is flowing in from the judicial precedents and the legislature which keeps making law. This is the beauty of law, and that is how it develops. Thereafter, the 2019, a very famous judgment came, again of Honorable Justice Nariman, which is Sangyong Engineering versus NHAI. Now, this judgment has again interpreted in the light of the amended Act of Arbitration that public policy now cannot be interpreted to be so wide as it was in the case of ONGC and SAW pipes, and even in our own judgment of the Associated Builders in 2015, because the legislative mandate says that public policy, so therefore the Supreme Court to substantial extent modified its own judgment in the case of Associated Builders, in the case of Sangyong judgment, saying that no, now that concept of perversity which we had brought in the interpretation of the public policy will not be there. But of course, some of the grounds which are bad, on which the award must be set aside by the court, can now be read under the term patent illegality. But the wide interpretation which has been given to the public policy doctrine for interference in the award should not be. So what is the trend which you see? The trend which you see, whether in the form of statute law or in the form of case law, is very, very clear that the courts are absolutely clear, the legislature is absolutely clear that the scope in the interference of the proceedings of arbitration has to be minimalistic. And that, according to me, is a very, very encouraging sign for all students and all aspirants who are in any form associated with ADR process, or as just the previous speaker was saying, that if you are making a career in law and in arbitration, then the field is wide open, and this stream of dispensation of justice has come to stay in this country, and we all have to make efforts that it is given effect to and it is strengthened in our country. But before I conclude in next 5-6 minutes, I would like to point out that, you see, timelines are very important. Now I want to share this experience with all of you, that as a lawyer, the changes which have been brought in, that now the arbitrator or the arbitral tribunal has to pronounce its award within a time frame. A new section has been introduced in the amended acts, which is known as section 29 capital A. It says that within 12 months of the date of entering into reference, of course, a slight change has taken place insofar as the entering into reference also is concerned between the two amendments between 2015 and 19. But let's keep that aside in simple terms. The upshot of the whole thing is that now the arbitral tribunal has to pronounce an award within a maximum period of 18 months whether with or without consent of the parties. But the court, and if you are not able to do it, then you have to approach the court of law to satisfy the court that why you could not complete it in the time. So you must go and you can, then the limited time is given. So that problem which was there in arbitration proceedings, that it was not fast and it was not swift, is totally done away with, I can tell you with on the basis of my own experience. But the problem lies that what are the expectations of a party when it approaches the dispute resolution mechanism of the arbitration? The expectations are very clear that if I have asked and I have asked for money, I must get my money as soon as possible. But on ground reality, is it actually happening? The answer is unfortunately no, for the reason that the arbitration process has been expedited, but the matter goes to court and it is virtually put on a kind of a speed breaker over there because courts are flooded with litigation. So therefore, the new act also says that as far as possible, the matters going to court from the ADR mechanism must also be disposed of within a particular time frame. However, recently, the Honorable Allahabad High Court in the month of August 2020 has given a judgment where it has held that that timeline which has been given to the court of law is a directory provision. It is not a mandatory provision. But as far as possible, the court should make efforts. But unfortunately, because of the flood of litigation, because of the paucity of time, the disposals are not taking place as efficiently as they should. But I'm sure that looking to the consistent legal philosophy, which the Honorable Apex Court, the Honorable High Courts, and all the courts which are following, that they are a clear signal of encouraging arbitrations in India. And I am sure that all of you who make a career in arbitration will enjoy your work. Thank you. Thank you so much. Thank you.
Thank you so much, sir. Your words will evidently act as a pathway for the participating members to expand their horizon in terms of international arbitration. And we are very thankful for you for contributing your time today.
Thank you so much. It was a pleasure to be with all of you. Thank you so much.
Thank
If
you,
anybody has a question, I think I have finished
yes,
it right bang on time.
Yeah, so we have certain questions coming
Yes,
from the audience,
please.
and we'll be holding a short 5-minute question answer
Yes,
round.
yes.
I would request the convener of LUMA, Swati, to please put forth the questions asked by the audience members towards sir.
Yes, please do.
Thank you, Iptida. Good afternoon, sir. The first question that we have is from Mr. Bharat Pandey, sir, legal advisor, ONGC.
Yes.
The question says whether the issues of termination of contract on account of its breach by one of the parties issuing shows cause notice for banning the erring firm or encashment of bank guarantee are disputes for the invocation of arbitration itself.
See, the question in itself is quite longish, but all disputes arising out of the contract can go in for arbitration reference, except the certain exceptions like rent disputes. And there is a famous judgment of Honorable Supreme Court, which is known as Booz-Allen's. The party's name is Booz-Allen's. I'm forgetting the entire name, but you will find it on any of the softwares. So that carves out only the very limited exceptions which can be not be referred to arbitration. Other than that, all disputes arising out of the contract can be raised. And in fact, there are cases where if there is an illegal termination and as a repercussion, the bank guarantee of the party has been improperly encashed, because most of the bank guarantees, because I have myself appeared in a couple of cases on this account, that most of the bank guarantees which are encashed by the other side is essentially a performance guarantee, which is in some form or the other is linked to the performance of a particular party, it has breached its obligation, or it is not doing well, or it has caused loss to us. So therefore, we are encashing this bank guarantee. So it is an arbitrable dispute, because there have been awards in which I have appeared where the arbitrator has directed refund of the illegally encashed bank guarantee with interest. Yes, thank you.
The other question is from Ms. Misha. The question says, is there need to redefine the concept of public policy despite the 2015 amendment for making India a hub for international arbitration for upcoming future in order to rise the ranking of India in ease of doing business report to encourage enforcing of contracts ranking? Over to you, sir.
Public policy is now very well defined, and the entire treatise on public policy is the judgment of the Supreme Court on Sangyong versus NHAI 2019, and it deals with all the issues relating to public policy. So I think the person who has put the question, if they can just go through that judgment, it will be a good treatise for them to read. Next question, please.
Next question is from Miss Shikha. Sir, she wants to ask you the question herself. So we'll be unmuting her. Shikha, you may ask your question now.
Sure.
Shikha, please unmute yourself and ask your question.
You can ask. I think there's some issue with the mic, so that the other speaker's time is not entrapped.
Sure, sir. Sir, she wants to ask that where can we do internship in our first or second year?
Join a good office. Join a lawyer's office.
Okay. Thank you so much, sir. Thank you so much for your time.
Thank you. Thank you so much. Thank you.
Over to you, Ibtada.
Okay, thank you. Thank you, sir. Thank you, Swati.
Thank you.
The last but certainly not the least speaker for today is Mr. Panchashidev Sharma, sir. He is an assistant professor at Faculty of Law, University of Lucknow, and is currently on a study leave to pursue his research at Faculty of Law, University of Victoria, Canada. He is the recipient of the prestigious Dean Research Scholarship to pursue his research on comparative constitutional emergency law in Europe, America, and South Asia. He has been the topper of both LLB honors and LLM honor courses at Faculty of Law, University of Lucknow. He has served as an assistant professor, Faculty of Law, University of Rajasthan, and he is widely admired for his publications at Cambridge Law Journal, Cambridge University, Comparative Law Review, Nicholas Copernicus University, Poland, and Brix Law Review, University of Tumen, Russia. Sir, we would be privileged if you could please enlighten us and throw light upon the various aspects of arbitration.
Thank you, Ibtada. First of all, I need to be clear with the question of audibility. Are we reverberating on an audible platform? Am I audible to all of you?
Yes, sir.
Okay, good. Okay, thank you. It's good to be welcomed in our own institution. I cannot, from an outset, let me tell everybody, let me welcome everybody, because I'm also a part of this institution. I'm also a part of LUMA, and I'll always be a part of LUMA. So I welcome all the participants, and I heartily welcome this effort to put an international conference on, or international webinar on such an important topic. Our university just celebrated 100 years. So it's also a very timely thought event. And also, it's also what I believe, only a person like Vinita Kachar ma'am's stature and courage could take up this issue in a traditional university and bringing so many brilliant people at one platform. Generally, two-day conferences are in a way that first day is theme setting and the second day is all about elaborating those themes. And I was going through everybody's work. Harjot is my senior. I've been with him on various platforms. He has actually summarized the area of international arbitration so well, and also national arbitration. I was also going through Miss Iram's fantastic journey of transformation, her own transformation as an arbitrator. I believe that all of us should record what she has said and listen to it, not only for the sake of arbitration, but also about how do you develop your personality from Aligarh to one of the best institutions, arbitration institution. It's a journey of like, it's a story to read and hear and to be encouraged and motivated. Shri Manish Malhotra ji, what a fantastic and detailed analysis of arbitration and going through all the provisions and motivating you. It's such an honor to listen to all these three speakers. Believe me, I'm under pressure to speak on this topic. But first of all, I should thank Professor C.P. Singh, sir. Sir, I've said it several times publicly and privately, and I believe that I have been to this profession, this academic profession for the last 6 years, but I've never seen a more charismatic dean in my life who has gone all the ways to help their students, their colleagues. What I'm doing today is actually because of you, because you motivated in me and you always stood by with me. I would like to thank Associate Professor Vinita ma'am. Vinita ma'am, you have been my teacher, of an amazing disciplinarian teacher, an articulated colleague, and one of the most helpful person one can ever find in a university. And of course, a brilliant brain with, I believe, the most gorgeous heart and caring attitude you have for us, for our students. It's admirable. Just 2 minutes for these bodies of these students like Ibtada, I see Anamika, I see like Swaraj and Maitreyi, I see Ayush, these bunch of people. Oh my God, what you guys are. You guys are fantastic. Like putting every month a webinar in this time, in this COVID times. If there is a Padma Shri in my hand to provide, I'll give it to you guys. It's outstanding work that you are doing. Thinking about a program, coming up with an idea, involving those many students. Like on third day, I think I have like 123 participants. I've never attended a webinar on the second day when there are so many participants. It's wonderful work what you are doing. My blessings, my love, my regards to all of you. And I believe you will keep on doing the same thing. You will keep on learning, and all of us will be collaborating with you on this platform. So I'm a constitutional law person. I'm a public law person. So a public law person should not speak about arbitration. That's the principle. But when I got this offer, why I accepted this offer? Because I'll tell you a bit of a story. I joined recently University of Victoria, Canada, and there is a center they call it UBIC Mediation and Arbitration Center. So all the disputes goes to that center, and a PhD student is nominated to that center to adjust all the dispute. And believe me, like first week I got an arbitration case, and I was doing an arbitration, a kind of a mediation. I could not call it arbitration. I was doing a mediation to a bunch of US students. Some of them were in Georgia, some of them were in Michigan. Like there were 5 students, and there was a fraud case, and there was a misappropriation of scholarship money case in which UBIC was putting their arguments on a digital platform. They use a platform called Brightspace. So they were doing it from Canada. Some students were in China, some students were in Michigan, and I was helping them come to a conclusion that how you can resolve that dispute. And I realized, okay, fine. That's an amazing area. I should study more, and I should go and read a bit more about it. And that's when I realized that how outstanding, how amazing this field is, and how amazing this field could be. And I started relating it to our own traditions. Like, have you ever heard, like anywhere, that there are 2 armies prepared to fight with each other, and there is a mediation proceeding going on? Who was doing that? It was Kauravs and Pandavas, and Krishna was doing a mediation proceeding. Okay, there is a possibility. It's like if you read that book, Argumentative Indian, it has used the story to utmost effect, that how much of a mediation is there in us. You see, in every every gully or every street, wherever there is a fight, irrespective of like the women are fighting or men are fighting, people will be gathered there to mediate and interfere into dispute. That do not happen in Europe. People do not get into somebody's brawl or somebody's fight. But in India, we do that because in mediation or conciliation or kind of a informal arbitration is in our blood. It's in our DNA. We do not, we always interfere into dispute. We always want to solve it and help it out. So that's, but why India has not become a center of arbitration? And what are the challenges in front of us with regard to international arbitration as a system and as an institution? So I'll talk about that because that is the area associated to me, and I'll also tell you about a bit of international arbitration. But that's a boring part. That I'll keep it to the end. I'll come to the I would say more intrinsic parts, that why India has not become and how India could become. What you guys can do, what institutions can do to change and to lead India into international arbitration. Okay, I'll ask you a question to all of you. How many of you have read this newspaper? Okay, don't answer, like just answer it to yourself. Okay, how many of you have gone through the initial page? The number will keep on reducing. The number will keep on be limiting. How many of you know what is the current international story right on? Whether it is the attack on Iran, or whether there is a new deal with AstraZeneca, the current Covaxin deal. So the problem with all of us is, like, when I was doing my undergrad course, I used to read 2 or 3 newspapers. It was a part of my habit. And there used to be 3 pages dedicated to international affairs. Now you see any newspaper in India, whether it's Hindu, Times of India, Dainik Jagaran, or any regional vernacular newspaper, there is hardly a page. Generally, it is half of a page, or at times it is quarter of the page, only to world affairs. That's the problem India has, that we are not inclined to learn and to know and to get informed about world affairs. That is also a problem our university is also facing, our faculty is also facing. I was just going Interim's work, and she has fantastically brought out that we study arbitration in 3rd year and 4th year. But you see, like, I was just going through the pattern of study at Oxford. Oxford introduces arbitration in 3rd semester. Now, just imagine, in 3rd semester, they are introducing arbitration as a paper. In 4th semester, they have a paper called International Arbitration. And also, they have choice-based credit system, which University of Lucknow is recently introducing, in which you can take a paper if you want to study international politics, because you cannot do international arbitration unless you're not aware about international politics or international commercial aspects. So until and unless how your interest will grow in this subject, it can only grow when you are aware about what is happening around the world. Like, just see, I was just going through certain problems that international arbitration is facing. Let's see, let's analyze them. Now, Trump age is over, Biden's age has come. In Trump, we have seen the era of protectionism. Trump's government was always against any arbitral award which is against a US-based commercial company. They have their unique act, they call it Arbitration Award Act, which is just a presidential order, and they have started blocking it, particularly for US companies. So what would be the situation when Biden will come? What would be the situation? How American firms, American legal sphere, American courts will respond to arbitral award? It's actually a key for us to understand. See the situation of bilateral treaty agreement between West and between rest. How bilateral treaty arbitral awards, how a bilateral treaty, like two countries or more than 2 countries, treaties, arbitration process is going on. What would be the situation of arbitration in Brexit? Like, Europe has changed after Brexit. The commercial space has changed after Brexit. Harjot is here, and Harjot would be much better than me to elaborate on that, but I think Harjot would also agree with that, that after Brexit, international arbitration and politics around international arbitration and mediation is going to change. Because after Brexit, there is, like I was going through a survey done by John Hopkins University, with saying that after Brexit, there is 78% more delay in enforcement of arbitral award in England. So those things are really alarming. Now see the emergence of China after BRI. What would be the situation? How many infrastructural disputes are going to arise? How the world is going to handle those infrastructural disputes? Those are very pertinent questions. And the role of Singaporean and Hong Kong bodies in international arbitration, these are very, very important questions. Another important area or important challenge for international arbitration is, I believe that has been a challenge, like regarding the arbitration proceeding on intellectual property. So we do not have so many expert arbitrators on that field. Similarly, I don't know whether ma'am is here or not. She was talking about it's good to see a female on body. Okay, ma'am is here. Hiram. I don't know, Hiram, like if you could elaborate us further, how is the gender diversity in international arbitration? It's so good to see a female putting a voice forward. Because last time I was going through the Hong Kong journey, it was like 12%. Is it something like that? Only 12% are female? That's a shame for international arbitration. So it's good to see an Indian female leading up to that area. So ma'am, you are an inspiration for us. If you could elaborate, like what is the gender diversity in international arbitration? So all the girls who are listening to it, it's an opportunity to
First of all, I would like to say, Mr. Sharma, that the way you are putting in and including students in this, it's really a wonderful thing. And I missed one thing, that it's my dream that every college should have a conflict resolution room.
Yeah.
So that is what the students should do it. And I am working on that. And we are establishing centers in different universities where the students will be doing mediation and arbitrations. This is what I'm trying to do. And if you're asking about the gender biasness in this, so many time I see that I am the single female who is being on the panel. And today also I was clicking the picture and I was thinking that I will post it on the social media, that look, this much is the female representation. And that is why I want to start a project, Women in ADR in India, very soon. And for that, I'm searching for the volunteers, some student who can volunteer with me. And I'm also the member in Women, Arbitral Women, and that has been now many organizations, they are coming up and they are challenging that very few females into this field. And the reason I do not know, because I've been seen always, I've been supported by men. It is not right to say that they are the blocking or they are the barriers, but I think that we ourselves the biggest barriers, because we hesitate, we ourselves will try to limit ourselves somehow. And I must say to all the girls and all the females who are sitting over, don't limit yourself, be the best pillar of yourself. Don't think that somebody will come and try to put you into this, okay, bhaiya jao, females bahut kam hai, you should be a female representation. No, you should take a lead, you should challenge yourself and remove all the limits, whatever you feel, because this is into mind. It's not exactly exist. Those limits doesn't exist. I remember when I was in the Hong Kong and I was cheering one arbitration moot, and I was the first person from India who was cheering that moot. So somebody was asking me that, ma'am, how could you fly every time in these kind of moots and all? I said, this is my passion. This is my passion, which brought me here and there every time. So that's what Mr. Sharma, I told earlier, that if you have some passion, then it should be in your blood and veins, and you should always think about it. And female biasness, genderness, this is what female thinks. Nobody stops you. You should come and practice into this. Many females think it's a very technical field, but no, it's not exactly as that technical. It's a very beautiful field.
And to add on with that, nowadays a lot of private international law disputes are coming. So in private international law dispute, if there is a dispute, like you have raised a dispute about a divorce, I was just working with a professor from, I think she was from Oxford University, Professor Paige Thomas, and she was referring me a dispute between, if you're aware about her, she was referring a dispute between a female couple who got married in Finland, and they were not accepted by a Singaporean state to buy a property there, because they considered that a female cannot marry another female, but like Finland has allowed that. So there are wonderful laws, wonderful areas venturing out, and they wanted a female arbitrator, and they were unable to get a female arbitrator because it's such a gendered mindset with which we work. So these are very pertinent things, that how we are going to challenge, how we are going to imbibe with that. I also want to point of view from Harjot sir as well. Like if Harjot is here, like what would be the situation of arbitration in Brexit area? Because I believe, like, as far as, like, I do not expertise in that, but after Brexit, there is a continuous pen in England to block those enforcement of arbitration awards, arbitration awards. So those things are a very like cautious area, a very important area. Harjot, yes, what is the situation?
Thank you very much. That's a very, very important point, and I should have dealt with it in my when I was delivering the lecture. But thank you very much, Panchashidev Sharma ji. You know, it's always pleasure to speak to you, and you're so intellectually stimulating, and you know, hearing from Manish bhai also, you know, it was very, very informative and very learning.
My pleasure, my pleasure. Thank you.
Yeah,
so much.
thank you, Manish bhai. You know, Mr. Sharma, Brexit, I personally think there would be a deal, and because even yesterday, the the negotiation team from Europe and the UK are in London right now, and it's a deal. It's a win-win for everybody, and because I do work a lot with the Conservative Party here, so in the discussions, there's a very, very big view now which is coming up, that the deal should happen, because it is interest of both Europe and UK. But to arbitration, even if there's a no deal, it won't make a difference, because the London is a very renowned center for arbitration, and there's a latest judgment of Inca versus Chubb by the UK Supreme Court just a few months back, where there was a dispute between a Turkish big construction company and between the Russian, because there was a Russian power plant. So there was an insurance dispute and for the power plant, and finally the Supreme Court held in UK, because in that case, the choice of jurisdiction, just on the brief facts, the choice of jurisdiction was London LCIA, but the governing law was not specified in the contract. And so the Honorable Supreme Court here applied the common law and said, look, you're not going with the English law, the common law, you know, which is India, UK, every country. They said common law is still applicable, and the law would be the common law and the English law. So very good judgment. And again, there was a French case. So, you know, LCIA is so proactive, and London as a seat of arbitration, it's immense. You know, we get so high volume, high in terms of the fiscal value, very high value of litigation. But, you know, coming to the other point, so on the Brexit point, I don't think there would be much of difference, even though I'm very positive that the deal would happen 100%, because, you know, it seems like, and it's in the mutual interest of everybody. Apart from that, you know, a very, very important issue that you raised with Interim about, again, she was so good and she spoke at length, and, you know, I never got a chance to compliment Interim and Manish by the time, because I was the first speaker. And, you know, it was very early in the morning, you know, and I was working till late because I've got a online, you know, we've got a hearing here on Monday. So I've got an online trial Monday, so I was preparing till 4. So, you know, but really, Interim spoke so good, and I'm so inspired by Interim. And Interim, I did send you the LinkedIn request also. And, you know, because Interim is right, you know, on the LinkedIn point. The students, please, you know, all of you from Lucknow, please have your LinkedIn profiles. Facebook, Instagram is good, you know, it's good for the fashion and other things, but LinkedIn makes you a professional. So please do that. and send requests to Iram, and she would really help you from India. And of course, I'm there, and the best thing is, Manish Bhai is there.
Not only students, I think faculty members also should have. I have
No,
never made a LinkedIn account. I'm going to make it today only.
please, Panch, Rishi, it's very important. But on the issue of gender,
And thank you
I
so
think
much. And Harjot, I accepted your request.
I know. I was on it. Yeah. Thank you very much, Iram. Thank you very much.
Thank
We'll
you.
connect because
Yeah, we'll
I do
connect.
a lot of arbitration, and I work with a lot of chambers in terms of promoting. And in fact, I was having a discussion with one of the senior advocates in India, and Mr. Hari Salve, who's based now in London. So he's doing all the litigation because since lockdown started, he's in London. He hasn't traveled. And you will be surprised with this online litigation, video conferencing. Mr. Salve has been doing all the hearings from here. Even the Reliance and Amazon fight, which is in Delhi High Court, even the Arnab Goswami case, everything is virtual. So I was speaking to him and another very senior set of chambers in UK, and we want to promote India as a next big, rather than, Singapore. I'm local here, and I'm
I'm
trying
also
to.
connected with one chamber.
Yeah, it's number 5 chamber.
London.
One of the top chambers in UK. They are to develop a good set of arbitration sets, which can, and amendment in the schedule will really help us.
Yeah.
So because they can get the international arbitrators to be appointed. But coming on the gender point, Mr. Sharma, you raised a very, very important point, and I've spoken to Sherry Blair, and he is very much interested in arbitration, and she always say, it took a lot of time for gender equality. Even Avila, who's the wife of Boris Johnson, and she's half Indian because her mother is from Punjab, and she's a QC, she's a Queen's Counsel again. She's one of the top lawyers. So even Marina Wheeler, please, even Marina Wheeler has been advocating that the gender equality, and they've been working really promoting the arbitration, among the males, and get the diversity right even here. So here, but to be really honest, a lot of females are there who are into arbitrations, and it's finally, but I think Iram would be a big inspiration, and Manish Bhai will be a very big support.
Thank you so much.
In India, we can promote, fairness, and law should be, because arbitration is brilliant field. So anything that we can do, Panch, we'll do it.
I got it. I believe like a lot of students will definitely look into it, and I'm sure Iram and Harjot, both of you, and Manish also will be getting a lot of requests for like associating with you or interning.
I got the request for the internship also.
That's what is when it makes actuality and virtuality together. Interestingly, like the reason to speak with such brilliant speakers like Iram, Harjot, Manish ji is that you don't need to speak a lot. They have covered everything. You just can like jump from another ahead with that. So that's why like another issue which I believe why India is lacking not only in students but also in international arbitration. It's also like we have to self-reflect into ourselves. The reason behind it, what I feel is there's a lot of speculative law student in first of all joining advocacy. From the emergence of these national law schools, trends has changed. Traditional university students were more focused going into bar, into like courts and doing a proceeding there or working with an advocate. But these national law school has changed the breeding pattern in India. Nowadays they are more into they want to go into against that. What I'm referring is that the courage factor or that every day. One thing I could do is like I can
try it now.
One more, I think with that, I'm set that. On that, I really want to from Manish sir as well, because that's what I've felt throughout teaching my students. There's a lot of insecurity. Now, there are two parts of that assessment. There is a lot of insecurity in young students joining, first of all, advocacy. Another thing is that from advocacy to arbitration, they need to learn the art of informalism. and learning an art of informalism because it's an informal platform, and also thinking and making ground there. That has been a struggling point for, I believe, for most of the students, whether it's a national law schools or whether it is traditional universities like us. And there is also another problem, which that I was referring, that how BCI drafts a syllabus. I'm not commenting on that, but you see that's the syllabus drafting is so outdated, and we at university have very minimal scope to change or adapt it. Although we try to do that, like Vinita ma'am putting this a webinar on international arbitration, it's a outstanding effort, because this is how we can change, or we can put a bridge up course to make them learn about the current day practice or the current day trends of advocacy. So Manish sir, I would really want to know your point, like how do we orient our students and all those students who are listening here, that how they can challenge themselves and coming up to bar and putting themselves in court, facing that everyday challenge and getting ready for that, if you could share.
I think it's a wonderful question, a very practical question which you have put. And now, after having put in 28 years in practice, and then in specialization of arbitration for last 22, 23 years, my experience is that, you see, first we have to focus on awareness. The problem is this, that the mindset has to be there that arbitration law is definitely a very nice mainstream litigative line, where, see, the only difference is that all the challenges which you have as a lawyer, and which I'm sure Harjot he must be realizing it day in, day out when you are contesting cases. In fact, my experience, I would not shy away from saying that today you are not at your creative best in the court of law. You are actually, as a lawyer, at your creative best as before an arbitral tribunal, because the courts are running so much short of time these days that, you know, there is a kind of pressure. When I am appearing in a matter, when I appear in an arbitration matter, I have the, of course, now with the seniority and coming in that kind of a privileged setup after so many years, I get equal audience in the courts also. But at the same time, let's talk in terms of the pure merit issue, that if you have to argue a section 34 petition in a court of law for 15 minutes, I mean, how are you supposed to actually give to the judge the entire perspective in the right way? So according to me, you have to inculcate in your students a very, very ground reality that it is a very, very important mainstream litigative line which you can seriously explore as a lawyer. Because you see, I have been going and speaking to a lot of law students in national law universities and all these places where I have been invited to speak. My experience is that 80% of the students are doing law, but they are not actually made aware by the institutions about the benefits and how they can apply their knowledge of law. What are their real avenues in life, to be very frank. So we need to encourage, and I think arbitration has to be brought. I was very clear in my lecture just now that I do not use the word alternative any longer now. It is a mainstream. That is why I started my talk with the fact that when it comes to court, the confluence is there. So these are two streams of river flowing, and the beauty is that how this river of arbitration is merged in the river of the courts will full respect and honor which is expected of this stream, which is of the ADR or the dispute resolution mechanism. We can just simply put it, it is a dispute resolution mechanism which has come here to stay. And so therefore, if you talk in terms of career in arbitration, there is, you know, I'll tell you a small little example. When Honorable Justice Chandrachud came to our High Court as the Chief Justice, and I was appearing before him in an arbitration matter, and the moment I finished my arguments in his court, the first question he put to me was that, Mr. Mehrotra, is there an arbitration bar in Lucknow? And so, frankly speaking, I didn't have a reply because I found that I am the only one actually doing seriously arbitration law. And there are hardly any people who are really ready to focus themselves on the concept of arbitration law. And it has room for every new talent. There is no dearth of work, but provided you do it, provided you give it the kind of attention which it is needed. And you see, you have to also, another thing which I would like to share, that the conference which I attended in Delhi, in Vigyan Bhavan in 2016, the Chief Justice of the Singapore Supreme Court, Honorable Justice Menon, he told me something so nice that I have tied it into my head. He told me that, Mr. Mehrotra, the problem is that we are all with the law. Nobody is with the cause. So, you see, we have to increase, we have to, educate people for the cause of arbitration. We have to, engage people. And it has come that you have to encourage and you have to educate them that it is a very pragmatic line. And then institutional arbitration, according to me, is a great thing which is happening to India. And there are a lot of areas where people have been approaching me that they want me to facilitate and coordinate setting up a nice institution in UP. And even the High Court is looking at it, how to go about it. But what I'm trying to say that it is definitely, second aspect is that children must be exposed to practical training sessions by senior lawyers and people who are actually engaged in the law practice. Because until unless they come and tell and educate the people and encourage the children that what is the option. Because you see, that is why the question which you just put to me, that people are afraid of going to the litigation. And that is where the quality is being compromised. You see, they are not wrong because they don't know. It has been, you see, stuffed into their heads that it is a very challenging job. It's very difficult to survive as a lawyer. But tell me any area. Did you get your stature in education so simply? I mean, the answer obviously is no. You have struggled. You have made your way into this stature of a good teacher by way of so many years of experience. So this is not to be shied away. It is a very important thing which has to be taught to the people. And a lot of people are just running away to law firms. What do you do there? You are basically, I have seen that there are a couple of youngsters who have joined my office that they got fed up in leading law firms of India after 2-3 years, with due respect to the law firms. But litigation needs quality. And until unless good quality people come in the litigation, it is absolutely the ADR impact will not be there in the society. That is very important. I mean, this is what my take is, that you have to encourage. This is the single line, bottom line of the whole thing, and encourage it for a bright future.
Thank you, Manishji. That's why I've asked this question, and I wanted them to hear from the horse's mouth. The person who has struggled, the person who has survived, the person who has made his name. That's the person.
And let me tell you that when I chose for this arbitration line, my own friends and everybody, they were very skeptic. They were saying that arbitration law in UP, in Lucknow, there are hardly any contracts. But today, my presence and appearance is pan-India. I mean, so therefore, I say that if I can do it sitting in Lucknow, why can't anybody else do it? There is nothing very extraordinary about it. You just have to work hard. You have to be sincere to your goals and your assignment. That's all. It takes you anywhere. People know me in Bombay, in Hyderabad, in Madras. There is hardly any court. So after all, it is not a joke. So if you can develop your talent, it is ultimately your hard work and talent which makes all the difference. So, and I am very actually hurts, because till date, despite best of efforts, I am not very happy the way the arbitration law is structuring up insofar as UP. There, we need good lawyers. There is no dearth of work at all. So therefore, I think a lot of encouragement is needed, and you have to have the faith. You have to have the faith. That's all.
Yeah, and perhaps that's the reason. That's the reason I've asked you this question, because I wanted them to listen it from you, like, because
Yes.
that actually matters more. The person who has struggled and who has made his name in that field, that
Yes.
should, and that's why that is actually the main reason, the core reason of putting a webinar on this topic and bringing people like Interim, who is an institutional academic and practical genius for international field, Harjot, who is an authority in itself, and a person like you who has made.
And that is why I am in full endorsement in was. Until unless you engage, you cannot make it into a movement. I mean, that's something very nice, which it was a very, very moot point which she touched. That you have to, until unless kind of a interaction between like-minded people, you have to build a team, and it only works then. And you know, this is exactly how an arbitration proceeding works. A good arbitrator is a person who brings on board everybody, because you know, otherwise in arbitration, small issue like fixing or next hearing can become a point of dispute. I mean, this is what I'm going to tell you. But you have to have that kind of a interactive association with each other, where you can actually exchange ideas. So I think a lot of regular basis seminars and coachings should be there. And I would like to also tell you that, see, the 13th Finance Commission, I had the privilege and the honor to participate in the training sessions of 1900 judicial officers, higher judicial officers of State of UP in Judicial Training Institute. I was the only lawyer visiting faculty in JTRI. And I have been telling all the judges, who are, most of them are now district judges, that you see, additional district judges and district judges, when they are operating as an arbitrator, as a judge in the commercial court, because now a new system of working has come up. So I am trying to, you see, also help in this field by creating a kind of mindset in my coaching sessions and in my seminars, training sessions, which I hold in Judicial Training Institute, to to sort of assist the judges to appreciate and understand the significance and importance of arbitration law in our country. And it has to be dealt with in a very, very specialized manner, and with the noble mission what the legislature has set in. Then only this will be, this is there. But this is something which has come to stay. Nobody can stop it, because no business entity is ready to waste even a single minute in the regular court of law for their any commercial dispute. This is the choice of their forum. This is their choice of their tribunal, and it has come here to stay, and we need good workers for that. That's what I can say.
So that leads me to my final part, like what are the challenges here? So let's summarize what these brilliant minds have told to you. So according to Manishji, now listen, like I want attention of every student and every participant here. So it can never remain an alternative dispute resolution. It is already become an additional dispute resolution, and for commercial field, it is the only dispute resolution field. Exactly. So you realize that time has changed. From Interim's point of view, you can also realize all of that any student, irrespective of their background, irrespective of their training, if he has or she has perseverance, if he has dedication and utmost efforts to bring a change, he can become a leading arbitrator, global leading arbitrator. And as Harjot also pointed out, that for that you need to know two things. First is an art of arbitration or mediation that you will grow eventually as you go into practice. But the utmost thing that is required is to be aware about your own laws, including your CPC, CRPC, and I'll add certain point on that, that if you want to be internationally good, you have to be aware about international news, international politics, international disciplinarity. So you have to change your approach from disciplinarity to interdisciplinarity. And as this transition will take place, you will automatically imbibe the art of international arbitration, also art of arbitration, because arbitration requires how you bring everybody on a single platform. The only thing I try to do in my deliberations is that I brought Manish ji, Iram ji, and Harjot ji in my lecture because I had nothing to offer, and they are so brilliant mind. So that's what an arbitrator does. So it's also a live example to you that how you can bring all of them together and how you can put a golden thread that imbibes all of these thoughts, and then only you can lead and change and become a means of change to the challenges or the problems of international or arbitration. So let's hear just few minutes on what are the challenges international arbitration as an institution and as a system feels. So this could be a boring part because this is what I've gone through. Like I've gone through some of the research work, and I have also spoken to certain people. So what are the challenges we have? I have primarily prepared it for international front, but I'll try to make it a more a national or domestic version as well. So the first problem that we face is decision makers or the arbitrators. Now, you have this trend in international arena where there is a private appointed arbitrator. And as soon as the decision is going to take place, like a Telsa case that happened in Germany recently, when there was an award going against Telsa, I think it was New York, it was a New York arbitration. Immediately Telsa asked the privately appointed arbitrator to resign, and they made them resign 4 times. So the case pendency in New York for that case, like it was 3 years, then 7 years, then 11 years, and now it is 13 years. So that is one area which international arbitration as an academic front and as a practice one should need to address, that how international decision makers or picking a private appointed arbitrator is hampering with the system of alternative dispute resolution. Manish has also pointed out that there was so much delay in a domestic arbitration case. So if there is a delay, the USP, the value of alternative dispute, or I would say additional dispute resolution, would be lost. And that is happening not only domestically, but also internationally. And with the emergence of Trump, Netanyahu, Xi Jinping, this populist government who is controlling the interest of global corporates, there is also protectionism around the world. How world is going to face that protectionism, it's a question mark. And I do not see a change is coming from Biden too, because Biden has also appointed a very conservative economic advisor. So I don't know how that is going to change. Second thing is the conduct of counsel or a conduct of an arbitrator. Again and again, I say that you may come from one ethical background, one legal tradition. Like for example, that a female getting married to a female is not acceptable in our society. I can say at least in our rural or our suburban society. But that could be a very acceptable thing in Scotland or in Finland or in any Scandinavian nation. So you have to put your ethical, traditional, cultural values aside and see a case from a complete partiality. Third is the efficiency of an arbitrational case. Recently, there was a Queen Mary and White International Arbitration Survey, which says that 68% believe that the international arbitration is too costly. 39% believe that lack of insight of the arbitrator was the issue why that arbitration award was not successful. Almost 40% felt that there was a lack of speed. And that leads me to a very important issue, the domestic courts. Are courts ready to accept international arbitration? And courts have a two-dimensional role. Are courts ready in domestic front to advertise and promote arbitration? And when we are talking about court, we should talk about all the courts. Like it should not be only the Bombay High Court or Gujarat courts who are promoting it, but it should be also about Patna High Court. Like I'm not putting any words on that, but are courts ready to promote alternative dispute resolution? That's a questionable thing. Second thing is that with respect of international arbitration, are courts ready to enforce that decision in respect of New York Convention and all other conventions? Those are also really, really important things, the challenges in front of international arbitration. But all those challenges are procedural. There is not a single corporate body or individual or lawyer or an academician who is saying that alternative dispute resolution or additional dispute resolution is not there. It's there to stay, it's there to change. It will change, but it can only change when there is a workforce, when there is a people like you coming into this field and bringing us a change in this field. And that could only happen with the organization of such courses, such interactions, because it is wonderful to interact with Iram and Harjot ji and Manish ji and all of you on a single front. I believe all four of us and all three of us that has spoken yesterday, and also our Vice Chancellor, Dean Sir, Vinita ma'am, and whole of the Luma team has only one desire, that you take this field seriously, you bring the medium of change, and you will replace the people right now here. Like, I would be very honored the day I'll get any of the participant, like maybe in 2050, if I'm alive at that time, who is ready to replace on it, to be a speaker on international arbitration, who would be replacing Iram or Harjot, or who would be replacing Manish ji. I think Iram, Manish ji, and Harjot ji would be also really happy that one of you, the participant or the audience, whoever is listening it from Facebook or from any digital media, is going to replace us in 2030 or 2040 or 2050, and also me. So that is the main like sutra or mantra or motion or motive behind this webinar. I thank you, all of you, from the bottom of my heart. I thank you, all the participants, and that is it from my side. So let's be a medium of change in this field. Thank you.
Thank you.
Thank you. Thank you very much. Thank you very much.
Thank you, sir. Thank you for holding such a beautifully interactive session, and it has all made it very certain that you are a fountainhead of illuminating ideas and extensive knowledge, and we are very incredibly honored to be associated with you. Thank you. Thank you so much, everyone, for sticking with us till the end of the program and making it more successful than we had anticipated. And we are highly grateful to you all for taking out time and being a part of the international workshop for not just today, but also yesterday. I would now like to invite Mr. Nishant Veer Singh, the convener of Lucknow University Moot Court Association, to please extend the vote of thanks and conclude the event. Thank you. That is it from my side.
Good evening to all of you, respected speakers, invitees, dear Dean Sir, Coordinator, Lucknow University Moot Court Association, and dear participants. I am feeling honored to get this opportunity to conclude the 2 days international workshop on the topic, Emergence of International Arbitration as a New Justice System in India, Future Opportunities and Challenges. Certainly, these 2 days were really amazing and useful, and we all got the opportunity to came across various aspects of arbitration. Organizing an international workshop is not a very easy task. It cannot be possible without great preparation, white working hands, and support from every corner and blessings. Now it's time to extend our gratitude to all those who had put their support to make this event a success. I am on behalf of the organizing committee extend our sincere thanks to Mr. Harjot Singh sir for giving such a valuable time, Ms. Iram ma'am who adjusted her busy schedule for this event. We humbly thank to Mr. Manish Mehrotra sir. As we all know, he has a very tight schedule in the court. In spite of that, he is here for this workshop. I extend my thanks to Panchashidev Sharma sir, former teacher coordinator, Lucknow University Moot Court Association. Thank you, sir, for your support. Ladies and gentlemen, our words may not be able to express our deep sense of gratitude to Professor C.P. Singh sir, Head and Dean, Faculty of Law, University of Lucknow. Thank you, sir, for giving us the opportunity to organize the international workshop on such a topic. And thank you, sir, for your constant support and belief in us. I am wholeheartedly thankful to Dr. Vinita Kacha ma'am for her dynamic leadership and support at every step. I am on a personal behalf, I am thankful to each and every member of the organizing committee who had put their constant support to make this event a success. And my special thanks to all the participants for giving such a valuable time for this event. Participants like Sudhir Kumar sir, who is always there for 2 days for such a workshop. Thank you, sir, for your constant support and believe in us. Thank you. Over to you, Ipda ma'am.
I once again thank all the speakers from the bottom of my heart on behalf of Lucknow University Law Faculty. Thank you so much.
Thank you so much. Thank you, ma'am.
Thank you very much, ma'am. Thank you very much.
Thank you. Thank you. I think we've reached the end of the program. Thank you all once again.
Thank you, Interim.